This matter we come for admission on court matter. Regarding this university matter, this appointment of the finance officer, it was
Oh,
heard by,
that case, two cases.
yes, you heard,
Mr. Thore appears.
yes, and this yesterday's this I don't know one this written argument, if should I file this event
What?
yesterday that matter Rajesh Mujumdar was there regarding this cumulative this
Dice known.
yes, madam. On the second file, madam.
May I please, your lordship. Lordship, I get to mention for listing lordship. My lord,
All listing matters. If not for today, give it to us. You see and distribute it. Him.
Yes.
You just see and distribute. Don't put it in a single day. Yes, Mr. Puri.
My lord, may I please the lordship for listing of an urgent motion matter tomorrow, my lord. My lord, what has happened, my lord, the Waqf property had been taken over by the government and the madrasa wherein this property is situated, my lord, they are restraining from functioning, my lord. So some chaos is there, my lord, that's why some urgency.
No, this is with regard to property.
Property, my lord, the.
Good then spoke.
No, my lord, it is a education academic matters, my lord. My lord, the Waqf property wherein.
Is Waqf a property is the place wherein the
A madrasa
is situated.
institution is established, my lord. Tomorrow, my lord, kindly oblige, my lord.
May I please it? I beg to mention item number 14, my lord. Only matter we can answer. Vacation, my lord.
On the prayer of item number,
14, my lord.
on the prayer of Mr. Kapalta. Let's this matter again after. Let's this matter again on when?
Bihu vacation, my lord. After Bihu vacation.
Why? No. 14 matter, no. You have it on second, 2-4. 14 matter can be. 13, 14. You gave a slip, that's why I'm accommodating.
Obviously.
May it please, your lordship. I beg to mention item number 12 and 13, lordship. Can it be on first week of April, lordship?
Second week, 12 and 13.
Lordship, 3rd April, lordship.
You are BC now. D Sham.
SRA Nasser on behalf of PD Nayars.
SI,
SRA Nasser. On
SRA Nasib,
behalf of
on
PD
behalf of Mr. PD Nair. Both 12 and 13.
12 and
Is this discussed again?
highly obliged.
Please, dear lordship, I beg to mention for listing admission.
For withdrawal item 34,
I may be allowed to revert to file a fresh lordship.
Mr. K. A. Mujumdar, Learned Counsel appearing for the petitioner on instruction permit that he be permitted to withdraw the present petition with liberty to refile if the occasion so necessitates. Full stop. Prayer accepted, the petition stands dismissed on withdrawal with liberty as prayed for.
Lordship, I am for Ministry of Health.
Huh?
I am for Ministry of Health.
K. Gugoi, Learned CGC appears for the Union of India.
Lordship.
For the respondents number
Lordship, 1.
seven, Union of India. In view of the orders passed today in the petition, ISC 454 stands closed. No further reported. Same stands closed.
Much obliged, Lordship.
There is an IA also.
top of the list, item 1,
Yes.
May it please, Lordship. Matter pertains to non-payment of pensionary benefit to the wife of the matter.
You were covered under the CPF scheme.
Yes.
When did the pension scheme come into operation?
Well, that
95 days.
I'm covered by my lord, the early pension scheme.
They are saying it's 95.
My lord.
So you died, your husband died in 91.
Yes. 90.
90. Then
My
how
lord.
can it be covered?
My lord, all the contemporary persons, my lord. who-
Contemporary persons,
They have
because they
been given-
continued.
My lord.
Yes.
They continued in their services.
Yes. My lord.
97, 98,
Yes.
2000.
My
So
lord,
they were
they-
covered by that 95 scheme.
Well, there is no specific government in the affidavit in opposition filed by them, my lord. Nor they have produced any records, my lord.
You dispute. Very covered by the, they have at least said that you are covered by the CPF.
Yes, only that statement.
But you have not countered that, saying that, no, I am covered by the pension schemes.
My lord,
You only say similarly situated persons have got.
my lord,
But the
Perhaps-
similarly situated persons got in 97, 98.
my lord. Perhaps this is not the prayer of his original petition, lordship, writ petition. Regarding the pension. That application has been filed under RTI, my lord. That was not, that is not his prayer.
So, Mr. Swigya,
But sometime may be allowed, my lord, to get the information, my lord.
we'll permit you,
My lord,
if you get some information,
my lord.
to prefer an application. Right?
Right.
Heard Mr. P.J. Swikyalan for the petitioner, also heard Mr. J.K. Kusami, Standing Council, APDC. The present proceeding has been instituted by the petitioner seeking pension, monthly pension, and other pensionary benefits on account of the services rendered by her husband in the erstwhile Assam State Electricity Board, now renamed as APDCL. So, the husband of the petitioner while working as a lineman too under the respondent authorities, he died of cancer.
My lord,
What was the date of the death? Somewhere I got it.
on 14/3/1990.
While was serving as sponsor on 14/3/1990, died in harness on account of being affiliated, on account of complications arising from, died in harness from cancer. So, leaving behind the petitioner and their children as his legal heirs. So, pursuant to the death of the husband of the petitioner, the respondent authorities released to the petitioner an amount of rupees 88,129, which includes an amount of rupees 59,773.10, being the CPF accumulation amount, and rupees 28,356.10 being the DCRG amount. So, the petitioner had received the said amount on 3/7/1991. Full stop. Thereafter, the present proceedings were instituted on 8/11/2012, praying for release of an amount of rupees 37 lakhs purportedly receivable by her husband on account of the services rendered by him, as well as the pension working out since the date of the death of the husband of the petitioner. Full stop. The above contention of the petitioner was disputed by the respondents by contending that the petitioner was covered under the Contributory Provident Fund scheme and had not been covered during his lifetime under the pension scheme. Full stop. It is the contention of the Learned Council, Standing Council, APDCL, that the pension scheme was made effective from 16/11/1995, and the scheme was named Employees Pension Scheme 1995. Full stop. It was also highlighted that prior to that, in the year 1991, the members covered under the CPF scheme were permitted to submit options for coming over to the pension-cum DCRG scheme. Full stop. However, the husband of the petitioner having expired with effect from expired on 14/3/1990, and the option as given in the year 1991 not being so given with retrospective effect, comma, the services of the petitioner's husband could not be covered under the pension cum gratuity scheme. Full stop. In the above view of the matter, the grievance as raised by the petitioner herein cannot be, this court cannot be entertained, inasmuch as the petitioner husband was never covered under the DCRG, under the pension cum DCRG scheme, and the scheme subsequently as introduced in the board was so introduced prospectively, and the same was not given any retrospective effect covering the periods prior to the death of the husband of the petitioner. Full stop. Accordingly, the writ petition is held to be without any merit, and the same stands dismissed. However, there would be no order as to cost. Full stop. At this stage, Mr. P.J. Sekia, learned counsel for the petitioner, submits that the petitioner has submitted RTI applications seeking informations with regard to the manner in which pension and pensionary benefits were disbursed to persons who were in service along with her husband. Full stop. It is provided that in the event any such information is made available to the petitioner, and they say establishes any of her rights, comma, she is at liberty to approach the respondent authorities by way of referring an appropriate application, and the dismissal of the present proceedings will not stand as a bar for consideration of such application.
Lords, much obliged.
Item 2,
Mozumdar called me, Lordship, just from difficulties for first half, Lordship. He has informed me, Lordship. And otherwise also second half, Lordship, I am some problem in Pathan matter is fixed. So Lordship, any other day, otherwise both are, we are prepared, Lordship. Any other day, Lordship. He is some difficulty, he just called me, Lordship. Regarding that certificate part, Lordship says query.
Is it the first floor or in the second?
No, Lordship, he is in the. No.
On the prayer made on behalf of the parties to the proceeding, list this matter again on 28/3/2024.
Lordship.
okay. Item 3,
Obliged.
Madam, the Lordship, regarding selection appointment government. My case is that initially I have been appointed as selected as Gamburam. Now subsequently the private restaurant.
Yes, Mr. What is this?
Lordship,
Where does your lower commissioner get a power to entertain this appeal?
Lordship, so 162,
One,
I think these
A.
are all left, Lordship. There is a
Mr.
power.
Kusur, you have that,
Yes, sir.
take it, Amlo, you have that book,
Yes.
this land living.
So 162 billion. Now it has been amended later on. Is that the matter that this matter is the prior to the amendment of this that executive instruction?
There is an affidavit by Revenue Authority here,
Yes, sir.
respond number 2.
Yes, sir. In fact, in the
So, Mr. You can't object. You have supported his case.
Lord,
See the file affidavit,
Lord,
deputy commissioners.
Deputy Commissioner
162A.
A. If it is my lordship appointed by the my lord SDO, then my lord is appeal lies before the my lord deputy commissioner. And the second appeal before the my lord divisional commissioner.
Here, the first appeal was entertained by the divisional commission.
My lord, if my lord this appointment is made by the my lord deputy commissioner.
Extra
then
assistant commissioner is nothing but
Nothing.
even lower than that.
Lordship, yes.
Now, nobody has entered appearance for the private respondent. Anything more, Mr. Bishop? Anything more you want to add?
But the only thing, my lord, since my lord, the appeal filed by him in a wrong form. That's
We are interfering.
This case, not my case.
No, we are interfering with the
Yes.
orders.
My case is that, my lord, since I obtained 65 marks.
You will have to be considered.
Yes, that is.
On the basis of lordship marks, the lordship.
See, preference would come in, it says suitability.
Yes.
If both are found to be equal place,
Equal,
then
then my lord, that
that-
equivalence will come, my lord, that way. Later on.
But Mr. A. Chaudhary, Lamek Council. For the petitioner, also heard. Mr. Hendrik, you will be appearing for
For lordship, one, I think,
one
one,
only,
only one. lordship. Deputy Commissioner.
for the respond number one. And also heard Mr. B. Dewey, learned
Respond number two.
junior government advocate appearing for respond number 2 and 1A and 2. Also. The present petition has been instituted by the petitioner hearing assailing an order dated 5/12/2023 passed by the Commissioner, North Assam Division Tezpur, in appeal case number 1/2013, by which the selection and appointment of the petitioner as the Gaunbura of
That is, my lord.
number two, do you number number 2, Itakola
Itakola.
Gaon. Also. Mr. Chaudhary, your appointment order is at page,
Yes, my annexure, my lord, annexure A, page 9.
no, that is your interview.
Interview. Oh, yes, sorry. That is
This is annexure B.
Annexure B, lordship.
page 11.
Also, the petition in pursuance to a due process of selection was appointed as the Gaunbura of number 2 Itakola, village of the village number 2 Itakola, by the extra assistant commissioner Sonitpur Tezpur, and he, on assuming such charge and on completion of the formalities as prescribed, was discharging his duties in the said capacity. The respondent number 3 hearing, who was also a candidate in the selection process for the post of Gaunbura of the said village, instituted an appeal before the Commissioner, North Assam Division Sonitpur, assailing the appointment of the petitioner hearing as the Gaunbura of the said village. The said appeal was so instituted by the respondent number 3 contending that he be the son of the earlier incumbent in the post of Gambura, he had a preferential right in the matter, and accordingly, it was he who should have been preferred for such appointment. Full stop. The respondent authorities having appointed the petitioner hearing as the Gambura had violated the provisions of the executive instructions holding the field in this connection. Full stop. The petitioner hearing had entered appearance in the said appeal and had questioned the jurisdiction of the commissioner, North Assam Division Tezpur, to consider the said appeal inasmuch as the first appeal ought to have been preferred before the jurisdictional deputy commissioner. Please have your seats. Before the jurisdictional deputy commissioner. Full stop. Ignoring the said objections, ignoring the objections raised by the petitioner hearing, the Commissioner, North Assam Division wide order dated 5/12/2023 allowed the appeal of the respondent number 3 by interfering with the appointment made in the case of the petitioner. Also, the appellate authority further directed that the respondent number 3 hearing be appointed as the Gambura of the village. Full stop. Accordingly, void an order dated 6/1/2024, while interfering with the appointment made, while setting aside the appointment made, while cancelling the appointment made in respect of the petitioner hearing, the district authorities proceeded to appoint the respondent number 3 as the Gambura. Full stop. It is to be seen that the petitioner was appointed as the Gambura of the said village after a due process of selection, where his suitability being adjusted to be he was appointed. He was recommended for such appointment. The respondent number 3 was also a candidate in the said selection process. It is available on the records. It's available on records that the petitioner had secured 65 marks in the said recruitment process, whereas the private respondent had secured only 39 marks. Full stop. It is to be noted that the office of the Gambura is not a hereditary one. No family members of a Gambura, as a matter of right, can claim to be appointed in such capacity by giving a preference. Also, the provisions of the executive instructions holding the field mandate that the selection committee shall ascertain the suitability of the candidate for such appointment, and thereafter, basing on such ascertainment of suitability, recommendations would be made in favor of the candidate so found suitable. Also, the contention of the respondent number 3 that he is entitled to a preferential right, the preferential right, if any, that may rest in a legal hair of an erstwhile Gambura, it would be to the extent of only that in the event such candidate scores equal marks with that of another candidate not having such hereditary, not being a son of a Gambura, son/daughter of a Gambura, then by applying the said preference, he would be so preferred for such appointment. Also, the preference here as projected by the petition is not a general, cannot be treated to be a general preference. In the event the same is so treated, the recruitment process as mandated in the provisions of the executive instructions would be negated. Stop. The provisions of the executive instructions, more particularly the instructions at clause 162A, mandate that that in the event the appointment is made by an authority below that of below the deputy commissioner, an appeal in such matter will lie before the first appeal will lie before the deputy commissioner, jurisdictional deputy commissioner. And it is thereafter only that such a person can approach the divisional commissioner. Also, in the case on hand, it is seen that the divisional commissioner had entertained the appeal as the first appellate authority. And in spite of due objections being raised in this connection by the petitioner hearing, also, the appeal having been so entertained without any jurisdiction, the order dated 5/12/2023 cannot be sustained, and accordingly, the same requires to be interfered with. Also, in view of the above conclusions, the order dated 5/12/2023 passed by the commissioner, North Assam Division Dispute in appeal case number 1/2023 is hereby set aside and quashed. Further, the consequential appointment thereon made. The consequential order dated 6/1/2024 passed in pursuance to the said appellate order dated 5/12/2023 appointing the respondent number 3 herein as the Gambura of the said village also stands set aside. Quashed. Accordingly, the order dated 26/10/2012 appointing the petitioner as the Gambura gets revived, and it is deemed that the petitioner is in service as a Gambura for all intent and purpose since the date of his such appointment, that is 26/10/2012. However, on account of the intervening factors, the petitioner not having been able to discharge his duties, the petitioner is directed to be allowed to resume his duties for the deputy commissioner, Sonipur district is directed to forthwith allow the petitioner to resume his duties. Also, the petitioner would not be entitled to any salaries for the period from 6/1/2024 till the date he resumes his duties. Also, on the date he so resumes his duties, the necessary emoluments due to him would be released with prospective effect. The above observations and directions, the petition stands disposed of. A salary litigation, emoluments to
But it's not salary, the honorarium.
honorary, emoluments, emoluments.
I love it.
Item 4,
So I am appearing on behalf of Ms. N. Sophia, my lord. She has got some health problem, my lord. She is unable to come to the court today. So it may be adjourned today, my lord.
Who is opposing this plan? Who is here? Respondent? Yes, madam, who is the respondent here?
I am not in this case, my lord.
Yes, police. Madam, give me 2 minutes. Will not pass any adverse order, don't worry. Yes, you are appearing?
It will be, the matter will be appealed by Mr. D. Bora.
Eh?
My colleague D.
Bora.
D. Bora.
Calling. Madam, don't worry. We'll see to that nothing adverse is passed. Just let Mr. Debora come. You wait for a few minutes.
item 5,
Because I find that subject to their saying, I find that he is entitled to that. So you let me hear that.
May I please, your lordship?
Mm,
The case of the petitioner here is that he was selected and appointed as a grade 4 employee under the establishment of respondent number 4
mm,
in the year 2006.
mm.
And
Others came in 2008.
yes, lordship.
Then,
Respondent number 5, 6, and 7.
Mm.
But they were selected without any interview.
Mm.
And even they were promoted for the post of LDA in the year 2013.
mm,
And the petitioner made his first representation in the year 2013,
mm,
in the month of December 2013, but
mm.
we didn't get any response to that.
Yes.
My lord, we don't have any instruction. Probably
Forget it. If
like
you don't
that-
have instructions from 2014,
Yes, my lord.
what to do? We'll direct.
My lord, by now probably he has been promoted.
Yes,
my lord,
madam, have you been promoted?
From 2014, my lord. Let her get the up-to-date instruction, my lord. Because I tried to obtain instruction from the concerned official, my lord.
Hmm.
They are saying that by this time, for 2014, probably he has been promoted, my lord. Because at that point of time, his grievance was that, my lord, private respondents have been promoted, superseding him.
No, that grievance still continues. We'll allow it. You have also not taken the trouble of filing an affidavit, 2014, 10 years. Why should we? Non-traverse. We will direct that she will be promoted from that day. And if required by bringing down one of those. They have also received their notice and they also have not.
Not to promote, to consider his
Not
case for.
Promote.
No, my lord, to
No.
consider his
Why?
case. If otherwise he is eligible.
Otherwise,
my lord.
what is the thing? You show me. 2 o'clock. Show me. 2 o'clock.
My lord, 2 o'clock will be difficult, my lord, because.
Otherwise, we are allowing this. And madam, you also take an instruction whether he has been promoted in the meantime.
Yes,
2 o'clock.
yes, my lord.
But today,
Yes.
if you don't get, I am allowing it.
Item 6.
You are appearing for?
For the private respondent, my lord.
You continue.
Yes, ma'am.
There is nothing here. You are continuing.
Yes.
Continue. None appears for the petition on call. Your name?
G Imtiaz, my lord.
Huh?
G Imtiaz, my lord.
G. Imtiaz.
Yes, ma'am.
G. Imtiaz, Learned Council, appears on behalf of the respondent number
5, my lord.
5. Also, the petition stands dismissed for non-prosecution. Kim, 4:15. If they come within 4:15, I'll restore it and give.
Yes, highly obliged.
7.
Ma'am. For indemnity petition retired, madam.
Very good. So you also give it a closure.
Madam.
What do you want here?
He sought, my lord, promotion with retrospective effect, my lord.
From the date his juniors were promoted. Why should we allow this petition? Where is the challenge to the promotion of the private respondents? Where have you made them parties? Why have you not made them parties here?
And I am not challenging there.
Then if I have to give you retrospective effect, I'll have to bring one of them down.
And second,
Sir,
my lord, there is no
No,
document.
cannot be. Without a vacancy, how will I permit them?
And second, my lord, there is no document to show that, my lord, the private respondents, those persons are junior to him, my lord.
Forget it.
Petition list, my lord, that they have annexed, my lord, that doesn't reflect that, my lord.
Abshir Ali. He was promoted. Okay. The promotion is 2008.
Yes, sir.
When did you come before this court? 2014.
13, my
Why?
lord.
13. You
Yes,
came before this court
Page 20, page
On-
20, madam.
No, wait. I have it here.
6/5/2013, madam.
12/2/2014.
Yes, madam.
You filed this writ petition on 12/2/2014.
Yes, madam. Before the madam,
Promotions are of 2008.
yes, madam. Before the madam, kindly say, ordered them 6/5/13, madam. Page
Where?
23. Page 23, madam.
Page 23.
Yes, madam.
Okay. Okay. Fine, no problem. Still 7 years. Five years.
I know, ma'am. Update of the case, madam.
These petitions will not entertain. Earlier one I was stern on.
Yes, madam.
This, sorry. Give it a closure.
Yes.
But Mr. Tsunami and Mr. D.P. Council for the petitioners. The petition here is was working as a lower division assistant. Petitioning hearing has raised a grievance with regard to the denial to him of his due promotion to the cadre of upper division assistant, now senior assistant. So with effect from 8/1/2008. Also, the petitioner herein was appointed as LDA while an order dated 4/1/86 on compassionate grounds. The petitioner continued to serve in such capacity and on coming to learn that persons appointed against the post of LDA month after the date of his such appointment were considered and promoted to the post of UDA. Way back in the year 2008, the petitioner made representations before the authorities concerned, praying for similar benefit. Also, thereafter, the petitioner came to be transferred from the office of the Inspector of Drugs, Borpeta, to the office of the District Medical Officer, Borpeta, and accordingly, he instituted WPC number 2318 of 2013 before this court in this connection. Also, this court, while an order dated 6/5/2013, directed the Director of Health Services, Assam, to examine the grievance of the petitioner as raised by him in his representation dated 22/3/2013 and to pass an appropriate order in the matter. Also, it is seen that in terms of the directions passed by, in pursuance of the directions passed by this court, the petitioner was while order dated 29/6/2023 promoted to the cadre of UDA assistant, now senior assistant. The petitioner thereafter prayed before the authorities for effecting his such promotion to the cadre of UDA with retrospective effect, that is with effect from 8/1/2008, when his juniors were so promoted to the said cadre. The same not having been considered, the present proceedings have been initiated. At the outset, it is to be noted that the promotions as stated to have been effected in the case of his juniors were so effected way back in the year 2008. The petitioner has even in the present proceedings, although they were in the present proceedings, instituted after long lapse of time, not assailed the promotions as made in the case of his purported juniors way back in the year 2008. Also, the prayer of the petition is for granting to him retrospective effect to the promotion as granted to him in the year 2013 to the cadre of UDA with effect from 2008. That is the date when his juniors were so promoted. It is to be noted that none of the said juniors who were reportedly promoted in the year 2008 have been away as party respondents. Also, there being no challenge to the promotions effected in the case of his purported juniors and the said juniors not having made party respondents in the present this court is not in a position to entertain such claim of the petitioner, inasmuch as entertaining the said claim of the petitioner would lead to interference with the promotion made of any one of his such juniors in the year 2008, which without hearing his doctor on this. Also, further, the promotions as noted as promotions of the juniors of the petitioner having been effected in 2008, and the petitioner at the earliest having approached this court after around 4 years in the year 2013. They approached this court in the year 2013, that is after more than lapse of 4 years, approached this court in the year 2013 by instituting WBC number 2318 of 2013, the challenge as presented to the promotions, even if a challenge is presented in the said petition to the promotions of his juniors, the same after such long lapse of time would not be entertained, would not be liable to be entertained. So, in view of the conclusions as reached here in above, the contentions raised by the petitioner in the petition is found to be devoid of any merit, and accordingly, the petition stands dismissed. However, there will be no more arrests. We'll not do that. something. Yes. Earlier case, yes.
Now
That I'm not going to leave it.
now he is happy, my lord.
That I'm not, now he's balanced up. But earlier case, it's a different
Yes,
thing. There is, everything is proper.
Item numbers 8 to 10.
Yes, Mr. Goswami, anything survives.
Lordship, only thing is survived, last read petition, Lordship can say the right, last read petition.
What is the number?
Number is Lordship will sign
5654.
5654.
Give me 5654.
Lordship kindly see page 121. Petitioner has already retired from service, page 121. Lordship, what's the gradation list? Lordship, as per earlier order in WPC number 994, OCBD Goswami versus State of Assam, ma'am, his seniority of the officers in the rank of additional chief engineer is fixed and final as follows. Now, Lordship, the OCBD Goswami kept second position.
Just a. List this matter before any other. Lohit Patel had appeared for it. Although in a different context. List this matter before any other bench without me. Not to leave it.
Lordship, I also want a little accommodation in Sanjay Montes case, item 18.
Huh?
Item 18, Lordship.
Okay,
Lordship.
same thing.
Lordship,
Probably something Lordship here also.
Here also Lohit Patak is a party.
Lordship.
Same thing, same order, 18. And appeared for him.
Lordship.
I had a doubt, Lordship.
Already long back.
Sorry, I missed out on that because I saw that, I thought there is nothing left here. So I did not go deep into it. Anyway,
Oblige, Lordship.
Item 11.
8, 9, 10 jabo, or 18 jabo. Item number? Continue. Mr. Devi. Not, yeah. Why are you sitting so far away? Huh? What is here left to be considered? Anganwadi worker, Anganwadi helper, promotion. Clear-cut affidavit saying she does not have the requisite experience. But none appears for the petition on call. But Mr. B. Devi Lana, junior government advocate for appearing for the state response. According to the writ petitions are disposed for non-prosecution. Nothing.
15.
Wait, please, Your Lordship. Better relate to selection and appointment. The respondent 5 is higher age, challenge, and the respondent number 5 is the higher age,
Higher age, condoned, but that age was condoned. Then next point,
Next one, the
change of the educational qualification.
subsequent Korean gender is
Origin.
change.
How did you apply? You are not entitled. You don't have a 2-year diploma in mechanical, right?
My lord,
You went to the office, you made a request that this 2 years is non-existent, make it 1 year. They made it 1 year. You also participated. So the corrigendum, you also know. Right? Without the corrigendum, you are also not coming in.
at that time, diesel mechanic 1 year only.
I know that. The original advertisement, you are also not entitled,
My lord,
right? See the original advertisement,
my lord.
page 17. Right? This advertisement, you are also not entitled. You went to the office, asked them, pointed out 2-year ITI diesel mechanic course is not there. So I found that statement somewhere. So did you make that statement or the respondent made that statement? Wait, just a moment.
They have
Para 5, page 5 of your writ petition.
Yes, ma'am.
So how can you now question that corrigendum? Other than the corrigendum, you have no case, right?
Fine.
Corrigendum issued at your instance. So you cannot feign ignorance of that.
But there is a no course of 2 years ITI teacher.
I got it. I got it. Let us see, the advertisement is 2 years. You went to the office, they changed it, right? You have written here.
Why not?
So the corrigendum, how can you now question? Unfortunately, you made it, he got it.
But the higher age part is there, my lord.
Higher age, they have said they have condoned it.
But
There is an affidavit.
effectively is there, my lord. But
Hmm.
my lord, if the advertisement does not, my lord, provide.
No,
it, my
no,
lord.
the 45 years, the government has power, 1951 OM. And okay. But I found that somewhere. Huh. Annexure A to the affidavit of the government. Condonation, so and so. Government has condoned. Why should we now come in? Who is appearing for the respondent number 5? Madam, you are appearing. Private respondent.
Hello, affidavit filed by the my lord, respondent number 3, my lord. Hello, annexure, my lord, page 5, my lord.
Hmm.
They have only as necessary action have taken, just written, my lord, paying for condolation of age and request your kind.
That
to
is
take-
it. That is appointing authority is the director.
Fine.
So the government was given in terms of this to take necessary actions, and you find that statement. And that was condoned, and there is a general statement also. Sir. Wait. Yes, madam, how was your age condoned? Any order? You have filed an affidavit here? No. Then? How was your age condoned?
Age was relaxed.
There has to be an order. Yes, Mr. Goswami, how was her age condoned?
The difficulties is there, sir.
If it is a difficult question, we will set aside. We'll set aside.
Difficult, at this stage, Lordship, I have some difficulties, Lordship. I am not with the, along with the brief, Lordship.
Then you no need, do not, you take yours. Will not disturb you. Yes, madam. Where is the order? You have not filed an affidavit. So the stand of the petitioner, who are you? Is there?
But Lordship, now petition respondent 5 age is about 55.
We will put him back on that day.
Now
Only 2 of you will. You goes, he comes in.
that Lordship, employer is the best person to.
No, no, you are the best person. How did you participate? Call your client. 2 o'clock. If you don't have that instruction, we are interfering with your point. Because that order is right, Deputy Commissioner Secretary did not allow. He only said consider. That he did not allow it. If they have construed it to be the direction of the government, they are wrong. So you don't have the eligibility to participate. So yes, that will be interfered with. He gets it or not, that's a different thing altogether. So kindly get that instruction back to him. 2.
16,
That is a. After that affidavit he had filed in the earlier case, what is left here? He himself, that Diasnon part, I was not very happy
Just took
while going through it. But then I found this affidavit saying that he files an affidavit before this court, kindly allow me to withdraw this writ petition on this.
No, he was absent all throughout.
No, that's a different thing altogether. But the issue is now, if that is Diasnon, the earlier period washed off. So for the subsequent period, he'll be the junior most, he'll not be entitled.
No, he'll not.
That's dismissed for default. If they come back, we will see.
Hello,
If they come back, we will see. Today only dismissed for default.
Lordship.
None appears for the petition on call. You are appearing for?
I'm for the 225 here. When this,
Okay, wins. Mr. Peter, right? Senior counsel, assisted by Ms. A. Chakraborty, appears on behalf of the ONGC authorities. Full stop. Dismiss the applications accordingly stands dismissed for non-prosecution. Mr. Roy, if they come back before 4:50,
Lordship.
please be here.
17,
May I please your lordship? Your lordship, I'm appearing on behalf of my senior counsel hospital for, actually he is out of station because of some urgency personal reasons, which therefore the matter may be listed after a few days.
Sir Kumar went today.
Yeah, yesterday evening he has to go outside. It may be fixed next week,
You are appearing for that private
Your
respondent.
Lordship,
Private
I'm appearing
respondent.
for private respondents, your lordship.
So you are appearing for Mr. Vishwan? Three. Has some problem, we'll accommodate. On the prayer made on behalf of Mr. B.D. Lalit, senior counsel appearing for the petition. And not objected to by the Lalit counsels appearing for the respondents. This matter again on 8/4/2020.
Can it be on 9th, lordship?
9/4/2020.
Eight lordship, I'll not be in station, lordship.
9th.
9.
Much obliged.
19,
May I please, lordship, in terms of your lordship's order, what are the remedial measures they have taken? Now also the director, lordship, the secretary has filed an affidavit saying that they will not recover, taking a plea that because of Rafiq Masih's case, we cannot recover the amount from retired employees and.
What about paying it to you?
Yes.
What about paying it to, when did they file that
Nothing
affidavit?
has been said about that, lordship. Lordship, my case is on a different footing, lordship, because I had
Yes, Mr. Das,
You
that's
said
not, that's not the answer.
lordship, I had pre-revised UGC norms of 52.5%. That is reflected at page 20 of the judgment, lordship.
Who said this is not? Who? We called him once. We let him go.
But this
But this is not the way he will deal with this court.
This is direct.
Mr. Das, you take your seat. You take your seat. Yes, Mr. Das. What is this? You admit that you have illegally given to somebody, right? And that you undertake before this court that no, we will recover. Now show me, ask him to file an affidavit how this money will not be recovered from his salaries.
My lord, the direct,
Tomorrow morning, I want that affidavit.
my lord, the direct.
We will recover the money from his salaries. Who is he?
No, my lord, the instruction that has been sent, my lord, that is the direct.
They have filed an affidavit here.
Yeah.
Affidavit says, director says it cannot be. Why? Who said?
Director.
Did you open? Did they ask for your opinion?
No.
Then
Or my lord, kindly pass the whatever I'll follow.
we are passing it over 2 o'clock. I want the instructions. Tell him this is not the way he deals with the orders of people.
Yes.
Either he will withdraw all those amounts or pay her.
Yes.
There cannot be a third way here. Mr. Das, this code is serious here.
Yes.
Mr. Das, 2 o'clock.
Problem.
35 of the supplementary list.
That brief note was actually supplied along with that page number 27. And he represented against it, against that particular brief note also. So it was not annexed to this particular writ petition.
Yes, Mr. Bora. What is this? Is this a disagreement note?
I'm sorry, Your Lordship.
Is this a disagreement note?
Yes, I agree.
We are interfering. Mr. Bora,
Your Lordship.
no other way out.
They have just stated a brief statement of the reason for non-acceptance of the commission's advice.
That's
also-
nothing. That's nothing. What was that? 1998 Supreme Court. Hmm. You can have your seats. That was 1998 Supreme Court 2-3.
RR Gavane was the state of MP, that case, Your Lordship.
What is the citation?
Citation is a 1996 judgment, but
I think it came late in the
late.
air, it came late. 1998.
Of course, after that, 2021, Sunny Abraham came.
Sunny Abraham.
Sunny Abraham came.
Sunny Abraham is the latest, but that flows from that one.
Yes, Your Lordship.
Everything flows from that one.
And Sunny,
Okay. Mr. Goswami, we'll pass orders. Interfered with.
36,
So we will say he is exonerated, whatever has been taken away from him, give it back. And regulate his pension also.
Yes. He retired as my lord joint secretary.
No option left, your lordship, because this agreement note is somewhat.
Can't help it. That's why I wanted that to be satisfied
one-
for myself.
One interim order was also there, my lord, in favor of the petitioner.
Oh, there is an interim order here.
Not to stay, but to give his benefit of promotions, etc.
Order dated.
Order dated, my lord. 7/4/2014.
A pendency.
Yes. Obliged, my lord.
Oblige, your lord.
Yes, Mr. Goswami.
Lordship, from the record, Lordship, it appears that evidence was not taken. Evidence was not taken, as well as the exhibit was, the documents were exhibited from the presenting officer.
And the initiation, what is not there.
Yes, but second line of argument, my second line of argument is that de novo inquiry may be taken. Because Lordship,
Why? Why?
yes, Lordship.
When the inquiry itself is without jurisdiction.
Because Lordship, this is so far the occurrence was the serious occurrence, Lordship. And the department, some technical faults, Lordship, the department is not succeed, Lordship. But at the same time, so far the position is, Lordship.
Okay, Mr. Goswami, your first argument is that the evidence in the inquiry was not received in the manner required.
Yes, Lordship.
Two, you admit that the PO producing the documents is not proper.
Lordship. Lordship, I admitted so far the submission of the petition.
Next is that you say that, Mr. Goswami, that there was no approval of the board before issuing show cause. Now, alternative.
Alternative argument is that, Lordship, that the method, the occurrence was a serious occurrence, Lordship. Bank have the pecuniary losses here in this case, Lordship. And Lordship, at the same time, Lordship, in this honorable court, the coordinate bench of this, your Lordship, pass such order for de novo inquiry regarding the same status of cases, Lordship. Yes.
My lord, Justice Suman Sham's order.
Lordship, my Lord Justice Devasys Bora's order in the same footing, Apex Bank case. Also, that matter is the prolonged matter, 2013 matter. Here in this case, Lordship, it is 14 matter. And superannuation, regarding superannuation also, we have our in our rule that the bank shall also be at liberty to initiate the departmental proceeding against the employee of the bank even after their superannuation for any pecuniary losses causes to the bank by negligence, misconduct, or breach of order by such employees to the extent of imposing penalties of recovery.
So you want me to pass an order?
Yes.
That initiation of a de novo is,
Yes.
if it is permissible under law, you do it.
Yes, yes, Lordship. From the state of interfering.
Anything more, Mr. Goswami?
No, sir.
That's not. Anything? Anything more left to argue?
No, my lord,
I thought there is nothing left to argue.
my lord, I'm coming to the.
See, Mr. Goswami is fair to that extent. And his second argument also cannot be washed away
No, my lord,
because the
I am.
charge is too serious.
No, my lord, I do agree also, lordship, charge is serious. Even in the charge of fraud and manipulation, Supreme Court never.
cannot.
No, my lord, I am relying also judgment. Now the question is whether after retirement a person can be, a departmental proceeding can be initiated.
If there is a financial angle here, financial loss to the bank,
Here financial loss was not there.
that's for them to decide.
No, no, the inquiry report specifically said so.
Enquiry report is bad. We say enquiry report is bad.
Now, my lord.
I'll only go by the charge.
My lord, I am not on that. Because there was, in this case, the charge sheet as well as proceeding all are non-east in the eye of law, right? Now the question comes, the bank has to draw up a proceeding by taking a decision to initiate departmental proceedings. Whether under the rules, they have the power.
That is for them to look into it.
Because otherwise, my lord, if the rules are not there, then I am relying on 2007 judgment, my lord, wherein Supreme Court says that you don't have any rule, then you cannot.
4 years. 4
No.
years.
Because pension rule is also not applicable.
No, no. Even in our state, if it comes, it's 4 years.
4 years from the date of
Occurrence.
occurrence. Here,
This side.
2006 occurrence, my lord.
But here he says that their rules permit that.
No, my lord.
Yes, yes.
No, my lord, that's
My
why
lord,
I'm coming.
Yes.
I'm
Mr.
coming
Goswami.
to that rule, my lord. Rule is, my lord,
Hmm.
if a departmental proceeding is pending and subsequent, during pendency, a person retired,
He continued. The
he
before-
continued, that rule is there. That, by virtue of that rule, they cannot initiate a proceeding at this stage, after retirement, my lord, by humble permission. Because after
They
retirement,
If there is no rule, they come.
because
Because here the interference would be with regard to the very initiation of the process.
here is very initiation itself. Because there was no initiation, my lord. That's the question here. Had it been an initiation there by the board applied their mind, took a decision.
And I would have only interfered with the second part.
Second,
Mr. Goswami, was this charge sheet at any point of time ex post facto approval taken from the board? After issuance of the charge sheet also?
Yes, lordship. Lordship. So for
in this regard, my lord,
regarding the
there
rules,
was a-
regarding the rules, lordship, I would like to submit, lordship.
Let's Mr. Chukotho.
I may be allowed to rely a rule, the judgment of Supreme Court.
Hmm.
Reported in, my lord. 2014. 2014, 1 SCC 351.
Hmm. 2014, 1 SSC,
Oh, yes, my lord,
351.
351.
Gopinath. Hmm. Yes,
My lord, may I take it straight away, paragraph 41, your lordship.
I'm there.
Has your lordship got it? I mark it, my lord. We are unable to interpret this provision as suggested by additional provision that once the disciplinary proceeding authority.
No
approves
issue. No, there's no proposition. That is the law.
Even, my lord, here in this case,
Hmm.
nowadays, my lord, may I coming to the rules, my lord.
Hmm. You just show
They don't have any rule so far the disciplinary proceeding, my lord. They adopted the rule of Assam government. Assam government rules specifically says the disciplinary authority will issue the same language in
rule 8.
rule.
They have a staff rules, I suppose. Apex Bank has a staff rule.
Staff rule, my lord. So far the procedure, no, rule does not provide any.
What do they say? That they will adopt the Assam disciplinary
Yes,
appeal? Just show me that.
Rule 120, my lord.
Mr. Goswami, you have a rule?
Yes, Lordship. Amended rule 46C, Lordship.
No, not there.
46C. The bank shall also be a liberty to initiate departmental proceeding against employees of the bank even after their superannuation for any pecuniary losses causes to the bank by negligence, misconduct, or breach of orders by such employees to the extent of imposing penalties or recovery from
that is-
retirement benefit. That is the rule.
That is what.
It's a staff rule, Lordship.
When did you retire, Mr. Kotogi? Retirement, your retirement?
My retirement date is, my lord,
During the pendency of the.
Note to good. 18. No. Yeah. Retired June 2020.
Huh?
In the month of June 2020. 2020.
And when was this rule amended, Mr. Goswami?
What's it?
46.
Long back. Lordship.
Yes. Mr. Kotogi, anything more?
Yes, my lord, I am coming, that rule itself. Rules has to be readable. For such reasonable period, it can be extended so as to enable the bank to complete the disciplinary proceeding initiated.
You are reading rule number?
Rule 46C, my lord.
See, notwithstanding anything contained in the staff rules of the bank for the time being in force.
Yes, an employee of the bank shall be subject to disciplinary proceeding for any alleged act of commission causing pecuniary loss of the bank or in any other way harming the reputation, prestige, and goodwill of the bank, and for any act violation of the provisions of bylaw and staff rule or any standing order, instruction, procedure of the bank, even after their superannuation retirement from the date of service. For that is the important, my lord. For such reasonable period, so as to enable the bank to complete the disciplinary proceeding. Am I clear to your lordship?
Okay.
That means, my lord, there must be a proceeding pending. A rule has to be read as a whole, my lord.
Just see the bold part thereafter.
Yes, my lord.
The bank shall also be at liberty to initiate departmental proceeding against employees of the bank,
Yes,
even after their superannuation,
yes.
for any pecuniary loss,
Yes,
cost,
yes, I
negligence, so and
agree.
so and so. Within
what
a
purpose?
reasonable period of time
For what purpose?
for recovery.
For such reasonable period, so as to enable.
No,
the
I'm not on
bank,
that. The next subpara to that.
Provided that, my lord,
No, there is another amendment in between.
initiated in the earlier.
Mr. Kutogi, just have a look at this. That is what I was asking.
Well, right.
Otherwise, what you are reading, that power is not there. They have amended that.
My lord, when this was amended, my lord,
That's what I was asking. When was it?
when this was amended, because the amendment fee. When this was amended, I am not sure, my lord. I have to ascertain it. Because otherwise, my lord, so far, I hope also the amended.
You were the standing council till when? 18, 17? No, before that.
The day after, my lord, also I was
You was there.
attached with the.
I know that. That's why I'm asking. you.
I have not, because I have that amended portion, my lord. But when this was amended, I have no.
Otherwise, Mr. That's the case, basically you want to project. If that bowl part is not there, everything goes.
Everything goes, my lord. That's why.
If that
my lord,
bowl
when
part
this
is there,
amendment was made, my lord,
if that bowl part is there,
my lord, that's why.
can you just have that instructions? Can you just ask someone if you're junior to come and tell this court at 2 o'clock?
My lord,
That
I
amendment.
have to do, my lord,
Just ask somebody, your call, that bank.
no, every link is connected, my lord, either expired or we are old people, my lord.
Oh, no, you have. Just have that instructions. We'll take it up at 2.
No, not, my lord, I have to check it up, because my client also, he's not.
Or we'll ask Mr. Goswami. Goswami, just have that instruction.
Once, 1 minute I will come.
You need not take 1 minute, you take 10 minutes, no problem. Mr. Kotoke, otherwise we are closing it. We'll only have that instruction.
Yes, let him. Look,
Let him place it.
I'll make my, whatever
Lordship,
submissions
lordship,
were done.
But please continue with your submissions.
Lordship.
Forget this, you continue with your submissions. Mr. He has undertaken the proceeding course. So you need not take the trouble of arguing the proceeding. Otherwise, Mr. Goswami is fair enough. He says goes. Now the only question is after it is set aside, because here the setting aside would also be of the show cause.
Look, I am coming to this power is there only to recover the loss and other portion. Otherwise,
Otherwise, that is not there.
otherwise.
Even
power-
that bowl part is amended prior to 2020, let's say.
Uh.
Then also they can't impose any penalty on you.
Yes.
They will have to establish the loss.
Loss part.
And the loss only can be recovered from.
Recovered from the other.
Otherwise, they can do nothing.
Nothing.
That is settled position.
Otherwise,
Mr. Kotogi, you do not worry. That this court
that
is aware.
have to be protected. because
That we will make it abundantly clear.
Clear, that other part.
Other thing, they can do nothing.
Nothing.
Suspension, dismissal, recovery. They can only, once they quantify that amount, that after an inquiry that so and so amount is recoverable from this man. After they prove it, only to that extent they can do it. Otherwise they can.
And the other, I am entitled to everything.
You are entitled to everything.
My lord, that protection, if you are not taking.
I'm giving you that.
getting it.
I'm giving you that.
Lordship, the amendment was done on the 11/2/2013, prior to the proceeding.
My lord, then.
And
11/2/2013.
yes, effect from 11/2/2013.
Sorry, my lord, I don't.
No, it's okay. It's okay. Because this is something which I also never saw.
My lord, this is so far the other amendments are there, my lord, but that part is subsequently.
No problem. And Mr. Goswami, even if we permit, it would be only for the recovery part after you frame charges against him. Prove it. Thereafter, you will have to. Right? You don't have a pension. You have pension. Pension scheme is there.
No, not there.
No.
And we will put a time frame. Within that time frame, you will have to do it. And if not done, full benefit has to be released.
Otherwise, I am entitled to full benefit. As your lordship said.
But only that part.
Whether loss is there or not.
That they will ascertain.
They'll have to establish. Because as per the inquiry report, no loss.
No loss. No.
So,
We will give them an opportunity,
uh,
saying that within a period of 1 month, if they have to take a decision, if there is a loss, then by following the procedure, issue a show cause notice. You make a reply. We will say within a maximum period of 6 months, this whole thing has to be thrashed out. And in the final analysis, if there establishes a loss, then to that extent, the amount will be recoverable subject to your legal rights. If there is no loss
to the bank,
then no money is to be recovered from you.
I'm entitled to get
all you will get back. But I think we'll suffer. Maybe by next week, order. Can I keep this?
Lordship.
Order by next week.
Bless.
Oh, इसको भी That's- Pick just the five. I take, no. 5 minutes.
I think,
He has a point.
yeah, of course.
Huh?
Jurisdiction,
Huh.
enough jurisdiction, abundant jurisdiction, doesn't.
Doesn't? Okay, give me those.
Cosmetic. Oh, this court also, recently. Scene number one, past final. 26/5/22. Paragraph 8.
citation kita koi jagah
Number. Paragraph 13/72. Paragraph 13, raising another. Under section 17(2) of the Act, all awards are final and therefore the same cannot be put to challenge by way of writ petition. Conclusion is paragraph 18. Lordship is reading the first one, my lord.
No, sir, I've completed the first one, para 19.
Yes, para 9, first one,
First one gone, para 19.
para 9.
The
Lordship has seen, my
petition
lord.
held to be maintainable,
Para 18, yes, para 18.
right?
Yes, yes,
18,
maintainable.
19. Second
Then-
one,
The second one is from Calcutta, recent, 22/8/22. Exactly on the
oh,
right.
it takes into
Yes,
concern the,
paragraph 7. Paragraph 7, next page.
Hmm.
Next page, page number 5, furthermore, from here, furthermore, first line is. Paragraph 7, next page, page 5, furthermore,
Hmm.
he submitted referring to section 17 of the Industrial Dispute Act that upon receipt of the award, the appropriate government within a period of 30 days from the date of its receipt shall publish such award and subject to the provisions of section 17(a) of the Act. The award so published under section 17(1) of the Act shall be enforceable after the expiry of 30 days from the date of publication and shall not be called questioned by any court in any manner whatsoever. Yes, no order rejecting any the award or modifying it has been passed in terms of the provisions contained under section 17(a) Calcutta Amendment. Award issued on 30th May 2014 has become final on 4th of October 2014. Upon expiry of 90 days of its publication on 3rd July 2004, is immune to any challenge on any expiry of such period, and hence writ petition challenging such award is not maintainable. He drew the attention of the court that the challenge to the award was made by way of writ petition filed on 17 December 14 by the appellant, when the award under challenge had already reached finality. Next, my lord, the answer lordship will find, my lord, paragraph, paragraph 10, page 9. Page the number bottom.
no, I got
Yes, yes.
9.
Paragraph 10. Absolutely clear from here. Now, with regard to the last issue as to whether award passed by the London Industrial Tribunal has reached finality, Chartered Council Senior, referring to section 17(a), the 17(a) of the Industrial Dispute Act, firmly argued that award passed by the Industrial Tribunal has attained finality in terms of the appropriate provisions of law. It is immune to challenge recording writ petition, challenging the award is not maintainable. In order to find the answer to the ground of maintainability to writ petition on award reaching finality, we may profitably refer to the fifth decisions, my lord. Now, paragraph 10(2), kindly see, my lord. Further, the Honorable Supreme Court in 1977 SC 237, while dealing the provisions of 9(1) of the Industrial Dispute Act, which provides that
no order of appropriate government or the central government appointing any person as chairman or any other member of the.
10.3. Main and the
Yes,
subparagraph.
yes, 10%, Lordship has got it, my lord. Next, absolute same point as the answer. 3, my lord, is Supreme Court, my lord, paragraph 14. Paragraph 14. Allowing counsel for the story and a contest, there is one more imprint in the court holding the C. Gupta not qualified under section 70 of the act to be appointed as a judge such as that. Finality of order constituting board, one, in order to depute government. Central government appointing any person as the chairman or any other member of the board or court or as the president of the labor court, tribunal or national tribunal shall be called in question any manner, and no act or proceeding before any board or court shall be called in question in any manner on the ground merely of the existence of a vacancy in or such. Next is important. It is true that section 9(1) is worded so widely and generally that it could never cover any or every challenge to the appointment of the particular post therein. But it is impossible to constitute the provision as a derogation of the remedies provided by Article 226 and 227 of the Constitution. Right conferred by those articles cannot be permitted to be taken away by board and general
Yes.
provisions of such, my lord.
Milord, first of all, Milord, I have not gone through those judgments. If I get the citations, I'll go through it. My first response to my learned senior friends,
I think this is what the first thought we had yesterday.
Yes.
yes, no, my lord, they have challenged this petition. There are two counts, my lord. This petition is under 226, not under 227.
See, the power, the essence of the decisions that he has reserved is that no act can take away the power of
I understand.
judicial review by
I understand that. judicial-
226, 227, technicality
Okay,
we
okay,
will not.
technically it is, I am not on that. What is, I am
So
on.
we'll have to hear
My
this case on merits.
No, my merit I will go into, but before that preliminary, whatever the objection I raised.
You want to respond to the citations? Mr.
Yes,
Nath?
I will take, my lord,
You
just,
take it, come back. Take it, come back.
my lord,
Let us not waste energy. You take it, come back.
yes,
Take it and come back. When? Today?
tomorrow,
Tomorrow?
tomorrow.
Tomorrow let us finish it, my lord. Tomorrow.
Yes, tomorrow. I will get some time.
Yes. Let him get some time.
No,
problem,
tomorrow
no
is
problem.
Friday. Motion
Well,
day.
My lord,
Give me
I will
give me
take
up
10
to
minutes.
2 o'clock.
I will take 10 minutes, my lord. There is nothing.
You are that latest Intel microchip. This is old 786.
No, my lord, I understand. My lord is 12th generation. That chip that my lord has.
Tomorrow.
Yes.
When he says I'm
Must
12th
be the-
generation, can't help it.
Yes.
When he says I'm 12th generation, I can't ignore that.
But he's more younger, my lord. Yes. Obliged, my lord.
Tomorrow.
Yes.
I'll take the citations, my lord.
Yeah. Hey, Mr. Ghosh, you just give him the citation. And give it from a book which he can never find out.
No, my lord. He's like, brother, I'll give him my photocopies of this, my lord.
My senior friends is more generous to me.
38.
Well, in this case, regarding the appointment of manual labor, manual assistant, my lord, in the Department of Meteorology,
Yesterday, there was a matter, they withdrew that.
my lord,
Mr. N.N. Upadhyay, he withdrew that matter, same challenge.
Withdraw, my lord.
Withdrew. Yes, Mr. Chetri.
That matter has already been.
Huh?
Yes, yesterday it was.
Withdraw. And you could force Mr. Upadhyay, you couldn't force Mr. Monto. Huh? He could pressurize Mr. Upadhyay to withdraw.
but my case is
But
not.
with you, it maybe not.
My case is not readable, my lord. My lord, is a very culpably, some violations are there.
It's a matter of 2014.
Whatever may be, my lord, there is a stay order in case of my lord, once post was kept vacant.
The order has not been continued.
So that is to be, my lord,
Not
carried out.
extended.
He cannot say that the matter is long pending, own one, so everything will go.
Yes, forget it. What is your ground?
My ground is, my lord, that this selection process that was constituted by the 5 members. One of the members was, my lord, the father of the one of the candidates who was selected as
Who is that? Respondent number?
number 3, my lord. Respondent number 3 is the father of respondent number 6. And record was produced, my lord, before that, my lord, submitting one thing, my lord, record was produced, and that was, everything was noticed by the honorable court, my lord, that some illegality here. That is why record was kept in the record, I think.
Who is respondent number 5?
5 is, my lord, one of the candidate against whom I said that he was selected, my lord, ignoring his age, because the age, his date of birth was, my lord, 71, and his date of birth later
Oh,
was
they
shown
had
as
given it some 84 or something in that select list.
selection. My lord, the record will show, because I have, my lord, gathered this
Select
information.
list, it is 84.
My lord.
Select list 84, admit card 74 or something.
No,
Right?
Yes, my lord, this is, his date of birth was, my lord, actually 1771,
71, in
But
the
the-
select
but the-
list, it is shown as
84.
1184.
84. So this was two ground, and third, the most important ground in case, my lord, there was a provision for women reservation, and the reservation was always post-wise. There were 3 categories of posts advertised.
Just a moment.
Yes, my lord.
Date of birth 1171, but select list 1184.
84.
Okay, where is that advertisement? Let's go
Advertisement,
back.
lordship will get a page 26 at Annex 1.
All these are grade 4 posts.
All are get forward, all are get.
So this will be one.
No, well, categories are different, man.
No.
Kindly see whether all posts are separate, man.
How many applications were called for?
I actually don't know whether the.
No, was application required to be filed separately for
Separate.
manual, for laboratory,
Yes, all are
for
separate.
pure? You have to, where?
I am for the first one, my lord.
No. Where was it written that there should be a separate applications file? It's one interview for all, one
No, well, a
selection.
separate interview, all candidates are separately interviewed, my lord. Not common interview,
Not common.
not common. In the
Select
all,
list,
all processed also.
manual, okay. Now you are only concerned with manual.
Manual, my lord.
Okay, now come to the
Qualification
select
and
list.
all things are separate, my lord.
Come to the
So-
select list.
So select list, my lord,
Huh.
this is published on
You have 20 posts, right?
20 for this particular my post, another for 2 and another rest one. That is for my lord 17, last one.
Hmm.
So all are different categories, my lord.
So out of this, what is the breakup? Unreserved 16.
Yes, my lord.
Okay.
All breakups are different. My in by case unreserved.
Now please come to the select list.
Yes, my lord. That was
Any
published,
lady here?
my lord, in this first category that is initially advertised in newspaper, that is Annex 3 as page 28.
Who is the serial number 14? Dimple Kolita?
Dimple Kalita is not my lord manual, my lord.
Is manual. Page 31, Annex 5. So
But
serial number 14.
this is Sri, my lord, but this is, I think, the
Sri, normally in Lower Assam, you write Sri.
Yes, my
So that cannot be the, and then you come to serial number 1422 at page son of, that is son of, okay.
1-4.
Care of. No, only one lady.
Ritu Mani.
Ritumuni, I don't think so. Ritumuni Kolita, son of it is. So.
But my lord, I came to that, my lord, they are affidavit, my lord. Initially, they are saying that there is no provision for women reservation.
Cannot be.
They say. But whenever they produce the parawise comment, and as per the direction, my lord, one copy was served to me also, that in that parawise comment, they given a different opinion. Let's see, we have to look at that parawise comment, my lord.
Where?
Very interesting, and what
Where?
and that parawise comment, what was apprehension was there, that was very much reflected, my lord.
No, where is it?
That is in record, I think, my lord.
The record is not here. Record is here. No, no.
Parawise comment that is on 31st 5/2019.
I don't have records. Separate
This is a
records.
record they have to produce by them.
Which one?
Mr. Goswami, you have a
A
record?
record in earlier occasion that was produced as per the Honorable Court Order 11/3/2019.
Show me.
That
So
was produced.
basically this respondent number 6 and respondent number 5, these are the two allegations. And the third question is woman.
The women reservation is a manual minor, not every candidate has been from women category and the minute of the minor there, this is minute. Where the candidates of the respondent number, this is selected candidate for the post of the manual, respondent number 6. His father was there and as per their statement and version that they, at the time of his interview, the father was absent. But the marking of the 5 members was there for calculating his efficiency. And this third one, my lord, they in Parawise stated that there was some difficulties in selecting the women because the work is like that and from my pleadings from
They
the very
cannot,
beginning.
they'll have to take an exemption under that act. If there is no exemption taken, they'll have to appoint women.
This is their view, my lord. They say that the difficult work, so it is not possible for a lady to go a distance along that and stay in a particular night.
Yes,
So,
Mr.
That ground, my
Chetty,
lord,
you are
was-
appearing for whom?
and apprehension was always there. I have reflected my petition also.
Huh? 5 and 6. So basically, this is the argument.
This is.
Let us see the records.
Yes, sir.
Also, we have the Parawise comment is very interesting, my lord, and their affidavit also contradicting with the Parawise comment. In Parawise comment, note A, nature of duties, that was how
This
discussed.
is section 5 of the Act of 2005 Women Reservation Act.
Yes, my lord.
So if you want, the power of exemption is there, but that has to be specifically done by the government.
Yes. And my pleadings, but I very much, that came later on. But from the very beginning, I say that because interview at the time of interview, I was repeatedly question was put to me that whether you were able to go in this place or that place or to stay a night in a particular place. And that apprehension, I expected that only that ground my selection would be rejected. And later on, this came improved by their Parawise comment. And in that particular respondent number 3 is not the only first person. In his earlier, his elders are also appointed in that same department by the same person. And his younger also same thing is happening.
A very good father.
Very good father, my lord. Being a minister, he is able to appoint his sons and a grateful employee, my lord.
Where are the records? Records.
Earlier, that was produced, my lord.
Records.
As per the last order, Lordship, so for the last order. The father of the respondent 6, Lordship, respondent 6, he was not there in the selection committee.
Mr. Goswami, those things are factual.
Then number of 5 members have.
I want to understand how you had conducted this selection. Whether there was 1 selection, whether there was 2 selection, 3 selection, 4, how much?
These are the
If
results.
there is 1 selection, there has to be 1 gradation, 1 select list. They cannot be separate.
The select list. The result sheet is there, Lordship. And percentage are given.
But from the nature of the advertisement and the select list, everything is showing. There is a separate selection, my lord. And merit is also prepared as per that.
Okay, is it my understanding correct? That 44 serial number, roll number, he got 29.8,
Yes, Lordship. Terror, Mr. Terror,
right?
yes.
Roll number 531 got 30.25. Okay. So till 1422, it is in descending order for manual assistant. Then you went to the next roll number, next descending number,
Yeah.
29.2. But there is 30.8, 29.8, 30. Why?
Lordship, the list is given in the first page, Lordship, select list. The select.
This is the result.
Yeah, yes, Lordship,
Right?
yes.
How did you segregate? How did you choose people for, say, manual assistant?
MA is the selection was single, in a single selection, single selection process, they were selected, Lordship.
Hmm.
And categorized as per their,
Marks.
yes, Lordship.
So categorization as per marks. But I find that person who have got 30, 30.8 were put as peon, whereas manual assistant, you went up to 29.2. Wait. How many ladies appointed?
In manual, nothing,
No,
not a
no.
single.
The manual assistant means that the work, the nature of work is,
Grade 4. I accept. We
Yes.
reject
yes.
Mr. Mountain. We accept you. That it is a one cent single selection. So all the posts are one.
One.
Only for the purpose of this, we have categorized. How many persons did you appoint? How many ladies did you appoint?
Regarding ladies, Lordship,
Mr. Goswami?
Yes.
Get me the original reports. Wherein the minutes of the selection committee is available.
Lordship.
Tomorrow. Tomorrow.
Lordship, may we fix on, after the holy, Lordship.
Why?
Any day, because
Own it, then get it. We have finished hearing.
voluminized record, Lordship.
And tomorrow, little difficulty on my part also.
In our office,
On
Lordship,
first of April or second of April, my.
no, any date, Lordship, after,
This
any
matter
day.
again on 3/4/2024. On which date? Mr. Goswami, learned advocate representing the respondents shall place before this court the records, including the minutes of the meeting of the selection committee, comma, the marks received by each of the candidate participating in the selection process, and the markings of the selection committee members.
And also, my lord, one prayer, my lord, the parawise comment that may be brought into the record, my lord. Parawise comment.
Need not.
Because my lord, everything was.
Once Mr. Monto has expressed his opinion on that, we have recorded that.
Right.
Just reiterate that.
Right.
Lords.
39 and 40.
Yes. Who is appearing for Riazuddin? You are appearing for Riazuddin. Yes, why was why did I keep it today?
My lord, that was pardoned, my lord, in the day before yesterday, my lord.
19.
The council for the
Yeah,
department, my lord,
Lordship
was
has given the.
directed to take any, if he could give any input, my lord. Lordship,
they have conducted the selection by following two different routes.
Oh, that,
Then 3 routes and then 18 routes. As it was,
yes, Mr. Kosik. Yes. Yes, Mr. Kaushik. Your gait today does not look to be very nice. Why? Everything fine?
no.
Huh?
But the only issue here is that by this state selection board has recommended 28 candidates. Madam. And this selection is not under challenge. Though, my lord, I reserve I leave it to your lordship to decide that, my lord, because it was
We'll
a
only be concerned with who is before us.
it's a
Rest,
mixing
what
up of
happens,
mixing up
Because
of
yesterday, the same documents came up. And Mr. Mohanto was there. The same letter, along with certain more letters were there. And it's clear that it was under the 2018 subsequently. So the exercise that was there earlier, under the 2003 rules, it died its natural. You could not have revived it in this. Even if you have revived it under the 2003 rules, we hold that it is continuing. Still, Mr. Monto cannot be selected because that amendment was done.
My lord, in fact, I would say, my lord, this is not a proceeding that has continued under the 2018 Act. Even if it is construed under this 2018 Act, then also the process would be wrong because
Because
there
then
is
he'll
no-
have to come in.
yes, and there is no district gradation list which has
Gradation.
been
Forget district, forget everything. If you are having a new selection under the 2018 rules, because 2003 rules, they'll be balanced or leftover.
yes.
2018 rules, it will be a fresh one.
It will be fresh one, and that has to be the consideration has to be given to all candidates.
So anything more? Mr. Tamuli? You don't seem to be very happy. Tell something. Make some submission so we also know what you also feel happy.
As per the record, under 2003 rules.
You are also Riazuddin.
Yes, Lordship, I am with the Riyazuddin Abdul Majid.
Poor man,
Neither
everybody against him.
I relate to judgment, my lord. One is
Lord.
Supreme Court, my lord, this is Umakant Suren case. Umakant versus State of Bihar. And that case also relied in a Bombay court, my lord, Bombay decision, my lord. Where it is saying that the,
Let him finish.
yes,
Yes, Mr. Tamuli.
Lordship,
I think you were supposed to give me a note,
no, in this case,
or not in this case, other case.
already I have given a Lordship compilation there.
We have seen that.
Lordship, once it is under, if it is under 2003 rules, they cannot change the rule in between. And if it is under 2003 rules, neither he is eligible nor I am eligible. Once it is under 2018 rules,
Both of you come in.
both of us will come in, and I being a senior,
You're senior.
yes, because he came on own request, transfer from another district to district under 2003 rules. And once
Mr. Soikia, your school name?
Dharmapur Gyanadayini Vidyalaya.
Huh?
Dharmapur Gyanadayini Vidyalaya, Kamari Muri.
Dharmapur.
Dharmapur. Dharmapur Gyanadayini Vidyalaya, Kamari.
And yours?
Lordship, Goldighola High School.
Gondi?
Mine replacement.
Huh?
Goldigla High School.
Mine replacement.
Okay. Gondi?
Goldigla.
Oh, Goldigla.
My interpreter was the earlier headmaster at the.
Oh, so.
And here, in my case, Riyazuddin, that is respondent number 6 has come on own request, transfer on own request, that I have
Record.
annexed. So he cannot be. And now that the notification of.
Not on request transfer, on request mutual transfer.
Yes,
Right. He says own request transfer. No, own request, mutual transfer.
And 2000, the circular they have issued in the notification they have issued in 2021. That is for everyone because they have not made any specific
No, no, because-
regarding that. So I will come in. 16 or 16. That is my son.
This is item number 39 and 40. Okay. Yes. Mr. Monto, you want to say something?
Why not? In this case, my learned friend, he has already admitted that neither he has the qualification nor me. So why not be on that issue? Why not be? I want to rely on judgment. Why not be Umakant? Why not state of Bihar? That is why not be reported in Supreme Court. Why not case? This is 2 judgment, my lord. And one is Bombay High Court that is relied in the same judgment, my lord, where it is saying that the person who don't have the qualification is a stranger to challenge the other appointment, my lord. Qualification have or do not have, it is not a matter of question. If he does not qualify this to challenge, he cannot. And the same thing is reiterated in the Bombay Court, where it is saying that although my lord rule was framed, but the notification came later on, selection took place before that. The only ground that on that day the notification was not there, so that cannot be challenged. So my case also the same. The entire selection process, the interview that was started in 2018. It is from May 2018 to 29 May 18, 2018. So during that period, the act has come. But because of certain official difficulties, that was not notified, that notified in 2019. So on that day, the second candidate, this is in respect of the Tony Chandra Burman, he did not acquire that qualification B.Ed degree. But I acquired this qualification and the act also there, only notification was not there. So that is to be taken into consideration. If he has not been qualified, he is not challenged by appointment. And
Mr.
moreover,
Monto.
one thing,
Mr. Monto,
my lord,
what is the value of an act if it does not have a teeth?
it is but
Till that time, it is the 2003 rules that will come in.
But-
It will hold.
but my
See, Mr. Monto, it's not a case that the Act 2008 came 2013 automatically got obliterated or obliterated.
that is true, my lord.
It got obliterated only on the date when the Act was implemented.
Yes,
Till that date, 2003 continued.
but this is
So it's not a case of a vacuum.
that is true. That one thing, one aspect also there. As the initial process, we are not considered because of the certain court cases were pending, and that was also very much clear from the all the notifications and when they were.
Your yesterday's case,
Yes, and when this subsequent effort was taken out to carry out to appoint this thing in 2021.
that
At
is
that
the
time
place
also-
where we have
At that
the,
time,
that is the place where we have the objection.
yes, my lord. So, but thing is that by process of these things, my lord, not only me
You
or
come
any other
back.
person,
You
all
come
together
back, we'll
28
pass the orders
persons,
at the earliest.
but they are not before a
Mr.
lawsuit.
Monto, at the earliest, why we are
They
not
were
concerned.
not before a lawsuit.
No, no, we are not concerned. We're only concerned with you. We are not concerned with anybody else.
But he
we-
did not challenge the
See, if
selection
that
process.
order of ours affects somebody, it affects.
But he is not
But
challenging.
we will be deciding only the rights of the parties before me.
That is true, my lord. But he is not challenging the entire selection process, my lord.
Need not be. He
It
is,
it
he is
is-
very selfish. He only knows about himself.
He is
He does
my lord,
not know public
he is
interest.
only to
Yes,
give
Mr.
that, so that the others should not be disturbed, that things will come.
Respect of the appointments of the private respondents.
No, whoever I hear,
Yes, that is.
only to that extent we will do it. We are not concerned with what happens outside.
One second.
Mr. Soikia and Mr. Tamuli, if they were large hearted, they had come up, we would have loved it. But now they are miserly, so we'll be more miserly.
Right.
We'll only limit it to that.
So the so this is a matter I realize that. It is first one, para 8, para 9 and 13. And second was my lord, para 12, 14, 16 and 18.
And this PIL? Who has given this? Center for PIL and another?
Mine.
You.
Paragraph 35. To reply my friend's concern.
But the challenge is not in the light of a public interest.
Mr. Soikia, sometimes too much would also sometimes take we may force to take another route.
My requirement at the Bhajan, but August I am going to retire.
We'll pass the orders immediately after Bihus. What do you call that? Holy you'll get it.
And the other person, he is gonna only join and enjoying the all.
But Mr. Kaushik, after we interfere, if we interfere, I think we will direct the director to have this thing done as a special case within a particular time frame. You do it in a manner required, but within a particular time frame. So that his rights.
Otherwise, otherwise, under the 2018 Act, we have already initiated the process. We
So-
need to include these schools and
Do it, but okay, that will also do. I think I dealt with one matter. Where is that notification? You have that notification with you somewhere?
Notification 2019, my lord.
No. There is a latest notification.
notification of July.
July, no. November 23.
The
Inspector,
it's
directing the
No,
inspectors to collect.
21, wait for I annex one.
No, after that,
after that. So those.
after my elevation. There was a case.
Oh, yes, recent one also. Yes.
If we can get hold of that, just give me, so I can
It
bring it in within the
is,
purview.
I think in 23, that was notification.
23,
November, I suppose.
23,
November.
23.
the inspector
Director
was
had written to the
to
inspectors to
all
collect the
inspectors to submit the gradation.
But he only, applied, my lord. As per my information, he applied for this post. Mr. Saika's client applied, my lord.
Advice. Advice has gone. Apply.
I don't know what Tamil is applied on.
There is a stay of filing in this case. Item 40.
But
You are holding the charge.
because of the stay order, my lord, this is only because of stay order he was allowed to continue.
So
Because
should
I
we
jo-
say-
Actually, I
should we
joined.
say that period will not be treated as administrative experience for him.
No, my lord, actually, I joined in the post. So what happened? my
So
lord?
don't open up.
But Tamuli's client probably not phase one also. So he till today also he not qualified to be my lord appointed as a headmaster. The first one value.
Okay,
Mass submission.
let's go dispose of. 3940.
For admissions, item 20 and 21.
My lords. Some other. May I please, your lordship?
I advance.
In the last order, we were asked to file affidavit regarding the students who got admitted. But now there are no students, so
File an affidavit. There is an order, Mr. Mahmood.
now case is ready for hearing.
No, Mr. Mahmood, there is an order. That whatever it's right, wrong, this court has passed an order. Honor it, file an affidavit. That much. Anything, whatever you, if it is not there, not there. Bring that on record, right? Yes, Mr. Counsel.
For
What
the
did-
time being, your lordship.
Okay, then you.
No, well, my senior friend would like to file an affidavit,
That-
but
that's-
take up some other.
That's. Mr. Mahmood, when can you file it? 1 week?
After vacation. After immediately after vacation.
On the prayer of Mr. M.U. Mahmood, learned counsel appearing for the petitioner. List this matter on 5/4/2024. Also, by the next day fix, Mr. Mahmood shall bring on, the counsel for the petition shall bring on the affidavit as directed by this court. By order dated 29/2/2020.
Item 21. Petitioner had it.
Madam, naam to likhi lo. Item number 21, so and so. List again, Mr. PJ Fukan, GU, apna AS.
Not GU, Milord, PJ Fukun is for the KK Handy.
KK Handy, Mr. A. Samoha for the UGC, Standing Council UGC.
All right.
22,
Admission fee,
Your lordship, for the time being, it's a similar case, Your Lordship.
No, 22 is not. I brought it.
No, directly.
Under release for provincialization of service.
Oh,
That's principle of Dollar College.
Yes. University system.
University system, Lord knows, my lord. But
This court knows many things, but it cannot.
my lord, what I am trying to produce
This
before,
court now knows nothing.
how can I say that?
Yes, I'm saying,
I can't say that.
you don't say that. You feel nice while hearing that.
No, not at all, not at all. My lord, this is a regulation that was applicable at the time of 1986 regulations. My lord, it was issued in
When was you, Mr. Soikia, when was the college affiliated with Gauhati University?
Gauhati University affiliation, 1989,
1989. And this is of 1987. What is your percentage?
my percentage is 50.25.
You give him a copy of this.
yes.
You take a copy of this. Mr. Soikia.
Fine.
They are now trying to say that you are, when you are here, when the college is being provincialized, one way of thinking at it, Mr. Counsel, relax, nothing is going to happen to you. On the date when it was provincialized, you did not have the UGC norms of that day.
Yes.
You are trying to project that the day when I joined,
Yes.
this was not the requirement.
Fine.
I continued. Now, yours college, according to you, when did you join the service?
I joined
August,
on
August.
6/8/1988.
8/8/90. That time, there was no affiliation.
No.
So affiliation occasioned in 1989. Huh?
Right.
So that umbilical code between UGC and the college came from 1989.
Right.
So at least on 1989, you must fulfill the UGC norms. What is
Yes.
that? Then you will be coming under. We'll try to examine whether that would be the university system.
Yes. List of that I have prepared. Yes.
So anything with regard to UGC norms would have come into being from that date of affiliation.
Affiliations.
So
Yes.
we'll say a date prior to affiliation, because if you fulfill that only, you get affiliation.
Yes, ma'am.
So 89.
On the
89.
basis of my qualification and qualification of the other teachers, my lord, college was affiliated by the university. My qualification was considered, I was never, at no point of time, I was rendered to be, my lord, underqualified or not qualified by the university.
You are saying this is 1987,
Yes.
and that is 55%.
That is
Give
all
a
along.
copy.
This is all along 55% is not never a compromise between. It is the only difficulty in his case.
Mr.
Otherwise,
Das,
That has been, my lord, in, UC itself, my lord, said that, my lord, that should not be insisted.
no. No. It insisted for persons in the university.
University system.
You came into the university system in 89,
89.
Yes,
and this is a norm of 87.
7.
So why will it not
That-
be
that-
demanded?
that 87 norms was, my lord, subsequently deleted, my lord, but by their amendment. My lord. I'll take a lawsuit to the
Subsequently
compilation.
deleted.
Yes, a compilation to us.
I remember you telling me last time.
Where it is?
Page 45 of my compilation, my lord.
Where is that compilation?
I don't have a compilation. Oh, hematology. Yes, yes. Paragraph 10. The minimum qualification required for appointment to the post of UGC lecturers, leaders, and professors will be those prescribed by the UGC from time to time. Generally,
The minimum qualifications for appointment to the post of lecturer in the scale for years of serving master degree in the relevant
Page
subject.
45.
Page 45 is the original notification, my lord. Contents of
In
paragraph 10,
45, it is there, same thing only.
paragraph 10, my lord.
So I'm reading
Then
paragraph
lordship
10
will-
only.
lordship will come to page 41.
40?
41, my lord. 41 is the amended version, my lord, of 1988, just before my appointment.
No, he did not have PhD, I suppose, at that time. This is
You
applicable.
didn't have PhD.
My did not have, but my lord, that 50% criteria was not no longer there. my lord.
Then PhD.
Then PhD.
Then PhD would come in.
The rider is
In
PhD. then.
You
order
have
to-
it. You have produced it, page 44.
Yes, ma'am.
That guidelines which Mr.
Yes, yes, ma'am.
So this is from 1986. Hmm. Okay,
1st January 1986.
and you say that now you basically given the benefit of that tutor concept.
My lord,
Why was he not recruited as a tutor?
I know that, 11 for, at the time of consideration, madam. We did not have this 55 qualification, that's why his case was not, selected.
but the state relaxation norms,
Regarding tutor, madam,
government of, State of Assam has relaxed that requirements also. ma'am. That relaxation-
52. 52%.
Yes,
What is your subject?
economics. ma'am. That relaxation was soon started.
Find out whether that is for the language subjects, literature. Where is that?
My lord, in the writ petition, I have annexed that, my lord. Page 67 of the writ petition.
ये नहीं, ऐसा तो नहीं।
Okay,
And in economics, my lord, 50% will do, my lord.
I missed out this compilation, the second part. Missed this yesterday. Okay. Yes, what to do, Mr. Das?
Introduction. 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 Tutor ticket put up in a ticket. Tutor principal हो कहाँ पे? मुझे मालूम नहीं।
next week, my lord, I will, take this discussion whether,
In the meantime, I have to return.
One day I adjourned it, I forgot. Now it's coming back.
1 week.
Just tell me, what is the bar in? Just show me the tutor concept here in the rules.
Also tutor.
Tutor is 655. Your college was under the 2011 rules.
My lord, it was another, 2011 act, my lord, provincialized.
11,
Yeah.
2011.
Rules को
655.
rules आगे जाएंगे provision. Rule क्या लिखा है होगा?
Act.
2011 Act का rule है ना?
11 Act.
Hey, it's not rules.
No. So three proviso,
My lord.
section 4, subsection 3 proviso.
My lord.
Provided that if an employee is required to acquire any prescribed academic or professional qualifications, service of such employee may be considered for provincialization if otherwise eligible. But in such case, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years from the date of coming into force of this act. And during this intervening period, he may continue to work under the existing terms and conditions under which he was working until his service are provincialized. In case of his failure to acquire the required academic or professional qualification within the stipulated period, his service shall stand terminated with effect from the date of expiry of stipulated period of 5 years.
Now, where is that order by which your thing was withdrawn?
My lord.
Impugned.
Impugned order.
My lord, my case was other staff, my lord, they provincialized at phase 44.
Hmm.
Of the repetition.
Of the petition.
No, where is that order by which they have decided? Because your salaries are not being released.
Not released. Page
So the-
42, my lord.
Huh?
Page 42, my lord, I just published in the website. Thereby, my lord, I was held to be disqualified.
Okay. Below norms.
My lord.
And page 44 is the regularization,
My lord,
the provincialization of your score.
Other staff, my lord. Even, my lord, the first two candidates, my lord,
Hmm.
at page 44, they neither have, my lord, NET or SLATE, PhD or
No,
MP.
but they have been given a scale also.
Yes, my lord.
Okay. Anything more, Mr. Chamun? Yes, Mr. Das, you were saying something. You want Mr. K. Gugui to argue? Mr. Sweke, anything? Nothing left? Mr. H. Sweke, Learned Council for the petitioner. Also had Mr. H. Chamua, Learned Standing Council, UGC, and Mr. S. Das, Learned Standing Council, Department of Secondary Education, Assam. Let's just matter for on the prayer of Mr. Vijay Sweke, Learned Standing Council for the God. K. Vijay? Spoken for what? Got it. Standing Council for the
They are
Formal party.
Formal party.
party.
He is there, so I have to record. Let's this matter again on 9/2/2024.
9,
2, 9/9/2, 9/4. sorry.
9/4. 9/4,
Sunday, my lord.
9/4, my lord,
Sunday.
can it be on different date, my lord? I'll be out of station.
That week will be motion day, my lord. That is why.
Oh, that will be motion day, right? Let us have it
Can
on
it be on
4,
5th? Can it be on
4,
5th?
4, 4, 4, 4.
4/4.
You have done your part.
Yes, 4.
Mr. Wow, Mr. Gugoi is there. If he
Yes.
wants to submit anything, make a submission.
Take a deep breath.
So on 4th, if we conclude, we get
But
time.
Gogoi has come.
I will one day vacations to get this thing.
Then also after.
He has done many times.
After we will.
No, before Bihu.
Before we.
Before Bihu.
Then also you will.
No problem.
Lordship will not make it reserve.
There are
Lordship will deliver then and there.
23 and 24.
You are appearing for which case?
And for 24, no? On the last.
Rita VIP.
Yes.
Okay. Yes, what do you have to say?
Well, on the last occasion, the lordship had pointed out that I had waived my right for consideration of promotion. Well, on page 32, which is the letter which I wrote, that I have waived I do not wish to be considered for the post of UDA because there is another second post of UDA which I can be possibly considered for, considering my eligibility and seniority. And that was stated in the writ petition as well, that this is of right to be considered for promotion is a fundamental right, and the Honorable Supreme Court has held on several occasions. One cannot waive.
Who
No.
said?
My lord,
Who said?
my lord, this. I
Show
have
me
written.
that judgment.
My lord, this,
Show me the judgment of the
I have-
Supreme
I have-
Court
I have-
which says
yes,
that you cannot waive your right for consideration for promotion.
my lord, right to.
Show me
consideration-
that judgment.
My lord, I have-
We'll
there is
dismiss this
judgment-
petition immediately.
My lord, judgment is the at paragraph 16, I have written about Bhairam Khurshid Pesika 1955 ARSC, which takes the doctrine of waiver will not apply to fundamental rights as a whole.
No,
Prior to that.
no,
Yes, my lord.
your consideration is one aspect.
Yes, my lord.
You want the promotion or not, that is a second aspect. What you are saying, you are foregoing not the consideration,
My lord.
you are foregoing the promotion. You have foregone the promotion,
That promotion itself.
and the
has not come.
promotion is not a, right to promotion is not a fundamental.
My lord, but promotion has not yet taken place. As
Why?
on data I considered, as on data, but promotion has not taken place. My lord,
Mr. Bhatt,
Yes.
accept this, you made a blunder,
My lord.
you made a blunder,
Yes, my lord.
you face the
My lord,
consequence.
but part one has gone blunder. Part two point is that I have challenged the impugned order on the basis that when I was promoted 1 month later, my three.
You
ACRs
should not have been considered 1 month later.
My lord, three years
You
was
should
closed.
have been considered 1 year later.
1 year later, my lord, but my three ACRs.
I'll
were
clarify.
considered. My three ACRs were considered for evaluated. In the case of the response 6, 1 ACR was considered.
Forget
And
it.
And the act.
Forget it.
My lord,
When did
this
you
is-
file this writ petition? You
this
filed
was
this
filed
writ,
in- this was-
promotions are of 2015. This is of 2022.
Yes, my lord.
When you are talking about fundamental rights, also you know the
Yes,
judgments of
my
the
lord, yes,
Supreme
my lord.
Court.
On delay and lashes, I am not on that point. I'm just pointing out on the grounds that there are two grounds. One is that waiver part. Second part is that ACR was
So
considered.
what
in
has
violation of
happened
the-
has happened.
Yes, yes, yes.
You accept that position and continue. Let him be the head assistant.
Well, I have no objection there. I'm just pointing out at page 26 on his own writ petition. Page 26.
Of the first writ,
First writ petition.
Montumedi.
Montumedi.
Hmm.
Now he was appointed in
Page,
2000,
page,
page
page.
26, page 26. This is his promotion. This is the promotion order. It's there. He has annexed it himself in exercise of power conferred under provision of Rule 7 of the Assam so-and-so rules so-and-so dated 24/6/2004 on the basis of recommendation of DPC and governing body resolution dated 19/11/2014.
Hmm.
He is appointed in 2012.
Hmm.
Promotion process takes place in 2014.
Hmm.
There is no time for even 2 years of ACRs to be considered by the DPC, admittedly on record.
Mr.
Nobody has denied that. And
Sorry,
My lord-
we will not hear this from you.
Man,
At least this court is not hearing.
Well,
Next forum, I don't.
my lord, on my only points are those 2 points. That is what the reflection is structured. On delay and lashes, I have nothing to say. If your
And if
lordship
you have
holds
any
that-
judgment which shows
that,
that a employee cannot forego his promotion,
no, employee, that is not. On 1959
so
AIR.
I'll also learn.
No,
So
no,
give me
my
that,
lord,
I'm
just,
with you.
just
If you don't have that, you don't have it.
Just as a general observation,
Where is Mr. Das, Rupam Das?
He's in a different court at
He was supposed to be here. You are here,
this.
it's even better.
But as a general observation, 1959 ARSC 5 judge.
No fundamental rights can be waived.
No, but two judges said no fundamental rights under 14 can be waived. 2 judges separately said no fundamental rights overall cannot be waived,
So at least under 14, you cannot waive.
at least under 14.
And right to consideration for promotion, Ajit Singh and that line of judgment says fundamental right.
Mhm.
But what you are waiving is not the consideration. You say, I don't want the promotion only.
And with that, I'll be considered for.
Then
other-
who are they to consider you?
He was considered.
So when it will be a futile exercise, if you say that I don't want, and the law is
Yes,
that in an event, a new vacancy arises, otherwise 1 year,
1 year.
or a new vacancy arises, then you can be considered in a fresh process.
Yes.
One. Two, if there are two considerations, the select list prepared in terms of the first consideration will have prominence. Yes, what do you have to say? What do you want?
Mine is simple, Lordship. I filed the petition.
You are very simple always.
Lordship, I filed the petition because my candidature was not considered, your Lordship.
Hmm.
Unanimously, the TPC has sent the name of the respondent number 6.
Now, 6 has not been promoted as head assistant.
No, because of the stay order, Lordship.
Stay order.
And after I filed the petition, Lordship, they have filed.
One allowed, one dismissed. Can't help it.
Blunders, man.
Hmm?
Blunders.
First blunder. This is the consequence. Because, see, it's fair on your part that you have not argued that. The contention in the writ petition is that I was coerced, I was forced. You are a mature, you are an intelligent man, I know that. So you have not argued that. How can this court at this stage consider that? Okay, we'll get the orders after Holi.
Much obliged.
I would like.
You don't dispose.
Yes, sir. 25,
Mr. Yeah, you have that order
Yes.
in that other case.
Other statement. Allot me.
What was that name, lady?
Allot, that was Navonita.
Navonita Mandal. Yes, Mr. Vora.
My lord. Also, we are supposed to dispose in that in the line of Nobonita Mondal, you know. But here, Lordship has asked regarding my lord provincialization order. But there, I can't produce my lord, but I have produced some other things, man. As per page 38, my lord, the approval is made of purely on temporary basis and may be cancelled at the time without assigning reason. The approval of teacher non-teaching instructor.
See,
Here, my
one factor here is
Yes.
in Navonita Mandal, she was appointed in 1990-91.
my lord,
Okay,
no.
it's somewhere near 88
Yeah,
when the
96.
college was moving.
No.
But she is 96.
My lord.
Yes, Mr.
My lord, there is my lord, no doubt that Navonita Mandal is senior, my lord, to me, but the sequence of events, my lord, regarding the.
What subject were you teaching?
Lord, I was an assistant teacher BA, my lord, at that relevant period of.
Everything.
Anything
But
can
she
be
was
taken up.
appointed additional teacher, that cannot
My
know.
lord, concept of addition.
That is what, right. That is what we wanted. Where is that? You're taking it from this order of approval,
My lord,
the district elementary education's officer's order.
my lord.
And Mr. Yeah,
My lord.
only this 1 to 7 were the teachers in the school, or there was somebody else also?
My lord, this one headmaster was there, my lord, he has abandoned before.
No, forget it.
My
Who
lord,
has gone has gone.
my lord,
But provincialization that has taken place,
second place.
between 1 to 7 minus 5 and 7.
No, my lord.
There are others also.
-5, no, others, my lord, there was no.
So who was initially, forget Navonita Mandal, because she was also not problem.
My lord.
So 1 was provincialized, 2, 3, 4, and 6.
6, my lord.
None else.
No, my lord.
So this additional teacher, what do you say?
Milord, at that relevant period, this is a event, Milord, took place long back in the year 96, Milord. At that relevant period of time, Milord, from my limited knowledge, Milord, it governs the, as this is an upper primary school, Milord. That 1977 rule was governing that relevant period of time, but under that rule, Milord, there is no number of cadre strength was also not specified, Milord. So not only in my schools, Milord, in many schools, such additional teachers had also been, because the dearth of the students was there. Therefore, the management committee, Milord, while appointed this type of teachers, it used the word additional teachers, Milord. But the nature of duties, Milord, and the services which were expected from us, Milord, is similar to the teachers, Milord.
Because why I'm saying so?
My lord, my lord.
They had sanctioned a particular number of posts,
My lord, my lord.
right? Those posts were filled up,
No, my
even
lord,
in the subsequent provincialization.
that's my lord, that's
One post was there,
my lord.
and that we said has to go to
Navanita Mandal.
Namanita Mandal,
Madam.
senior three. Now, those posts which were created for that school,
My
at
lord,
that point of time,
my lord.
exhausted.
6 months. Now, my lord, they can, supernumerary can be created at this moment, no, because it has been, my lord, may kindly appreciate, my lord, they have classified me, only, my lord, I have been dropped. Now, why I have been dropped, my lord, this is not as a till that reason from the government has not come up before my lord. Now, my respected friend has said that my lord, she is an additional teacher. That's why we could not create the post or cannot be provincialized at that time. But my lord, this is his respectful submission before my lord.
School sanction was 6 posts of
Six.
teachers
6, my lord.
or 7.
6, my lord. 6.
Plus 1.
My lord.
Grade 4.
Grateful, my lord.
6 plus 1 or 5 plus 1?
6 plus 5, 6 plus 1, my lord.
6 plus.
Because she was appointed an additional teacher. There is no provision and direct.
No. Forget it. 1988, 6 posts were sanctioned, right?
My lord.
Right? Where do I get it?
That
Mr. Bhuyan?
sanction letter is not here. Can be. My lord, may I be permitted to bring into my lordship's notice an order, my lord?
Yeah, please.
Look, may I kindly turn to page 75, my lord?
75.
75. This is an order, my lord, issued by the district elementary education officer, wherein, my lord, similarly situated.
Additional teacher has been provincialized.
Provincialized. So, my lord,
There are 2-3 orders brought in.
There is
I'm
a
not on that. I'm not on that.
sanction-
What I am on
sanction
is-
strength, my lord.
The original sanction was 6
Six.
plus 1.
1, 7,
Okay. Now you come to the approval order,
months, 38, my lord.
30. 1, 2, 3, 4, 5, 6 plus 1.
The whole world is like-
And Mr. Bhuyan, this 6 posts were sanctioned in 88.
My lord, that sanction order.
No. That's what is continuing because they have not given any fresh sanction. They only opened that.
You can presume only, my lord, from the sequence of events.
Naturally.
My lord.
Okay.
Look, there is another event, my lord.
Hmm.
What has happened, my lord, that serial number 1 in the approval order was retired in the year, my lord, 2005. Now, my lord, thereafter I made an application, my lord, may kindly turn to page 44.
His services were not provincialized.
No, my lord, his service was not provincialized. Before the provincialization, he retired for our inspection, my lord.
No. It was given retrospective effect. 1990 onwards. So he having been there from 76 His services from 88 were provincialized. He is provincialized from 88.
My lord.
So he utilized that post.
My lord, I made a representation at page 44, my lord, to the headmaster, but this representation has not been finally, my lord, concluded, my lord. There is an order that I should be promoted from additional to assistant, my lord. Vernacular is at page 45, my lord.
Okay.
My lord, another aspect is there, my lord. Uh, another repetition, my lord, which my lord has already confirmed that the order dated 15/11/2019, referred by the same petitioner in paragraph 9. This honorable court has categorically observed at page 62.
Page 62.
62. Be that as it may, if the provincialization of the school had been kept in abeyance for.
I got it.
My-
I marked it.
Yes, yes.
It's already marked.
So, my lord, the one benefit has been given, my lord, so I humbly and respectfully pray, my lord, that this lady is almost on the verge of retirement. So she is even.
Let us see, Mr.
Fine, fine.
What best we can.
Yes, yes, yes. She is
Let's go.
even unmarried also, my lord. That is another benefit.
26,
Obliged.
Obliged.
May I please your worship?
Hmm.
See here, my lord, already they have sent it for legal views, my lord, to the council, my lord. So kindly some time may be allowed, ma'am.
You are speaking in such a film that it has sent to some other. It's come to you only. Nalai, give it back. Give some time. List this matter again on 5/4/2024, by which date Mr. Fukan shall place the requisite instruction necessary, shall receive the necessary instruction in terms of the early orders of this.
Deeply obliged.
Highly obliged.
27 to 29,
This matter may also be fixed on 9/7.
Right?
May please worship. Well, it relates to provincialization of service, my lord. This petition was, they were appointed librarian, my lord. They have the requisite qualification, my lord, at the time
But
of.
till what stage did your case was considered, which stage your case was considered under that 2011 Act?
11 Act, my lord. 11 Act, the district school committee, my lord, they sent the proposal, holding me to be qualified. But at the time of provincialization, I was, my lord, hold to be under.
No, your case was not considered approved by the SLC director. Government did not sanction posts.
My lord, they did not sanction.
So under the 2011 Act, gone. So you cannot be considered under that law.
My lord,
Your case will be considered under the 2018 Act.
79.
Dispose it of. Directing them to take a call under that act.
My lord, that before that, lawsuit has to, my lord, hold the petitioner to be qualified, my lord, under the,
That they will consider.
because, my lord, they have.
Oh, why should I?
They have already missing the, my lord. They have already held, my lord, to be to, my lord, underqualified. My lord, lawsuit will find the minimum qualification requirement, my lord,
Your library assistant, librarian.
librarian. My appointment, my lord,
Lordship is taking up 627, my lord.
Hmm.
627.
Hmm.
My appointment, Lordship will find at page 24.
Hmm.
That was issued on 1/2/1999.
Hmm.
1/2/1999.
Hmm.
And at the time, my lord, the 1991 my lord, regulation was in force.
Hmm.
Under the 1991 regulation, Lordship will find the,
Have they filed an affidavit here?
they have filed, they have filed.
Come, let's come to the stand.
In their affidavit, my lord, they says the notification of 1999 is not concerned requirement
Okay.
paragraph 6. They want to say, my lord, it is applicable to other colleges, not this type of colleges. That they have done, have done wrong, my lord.
When was this affidavit filed? 24.
It was filed on, my lord, last week, my lord, 14/3/24.
Yes, Mr. Das.
Hello, any other date, my lord?
Wait.
Actually, Mr. K. Gogoi has already spoke to him, my lord. He wants to argue on.
The Gogoi asked me, my lord, for taking up this matter on 4 along with the other matter.
Not 4, my lord, it's 9, same day. 4.
This matters on the prayer of Mr. S. Das. This matters again on 9/4.
Lordship has fixed the other matter on 4/4, my lord.
4/4. 4/4.
Oh,
Fine.
My lord, in the other matter, my lord, Lordship has heard the matter, my lord, but it was earlier once, my lord, released from Padar. Lordship may record the
No,
item 22, my lord.
which one? Which one?
Item 22, my lord. Lordship has completed the hearing almost,
Oh, that matter.
my lord.
22 for further hearing already.
Obliged.
30 and 31.
Relating to provincial national service. On the last occasion, Lordship, they release of instruction, taking the step that has already been taken in the individual.
Well, last one probably so far I remember, well, he was
Page 49. Why is he not there as tutor? Admittedly, he does not have qualifications, so tutor. Right, that is your case?
Yes, that is. In fact, Lordship, on the very day of consideration of this claim of the petitioner, she was eligible. Because she obtained her HCD subsequent. As per provision, Lordship, on the day of consideration, eligibility is to be determined. Apart from that,
Where is that statement of yours? That you are qualified, subsequently you acquired.
yes,
which
Lordship,
is Page,
Lordship, I have annexed the document, page Lordship 18
of the repetition.
in the reputation. Case as past certificate, and I have also completed DNA.
DLN I have seen this.
this is dated 11/3/2018.
Okay, if you see that 5 years also, 1/1/2021, and she has 18. Where is your provincialization order?
Provincial of one teacher, that is Lordship,
No, other teacher.
yes,
Where is that?
Lordship, that is page 24,
20.
4, and 26 is the relevant. 37, Lordship, page 26. Kanchan Rudropal, 87. And assistant is a post vacant.
This is done with effect from,
Well, that was under 2011. 1/1/2013.
okay. So yours will be under now 2017.
17, yes.
So higher secondary 2018.
My lord.
When was the DSC recommendation?
Mother. DHC recommendation that lordship has not been annexed. Because that. Subsequently, lordship, the report,
It is of 2000, this is the earlier one.
my lord, yes, that has done this. 41, your lordship will find.
Mr. Bora,
My lord.
this order that has been passed,
My lord.
this is in terms of the consideration made, what do you call that, under that 2011 Act.
My lord.
Okay, fine, he is not qualified, let us accept this.
My lord.
But now the 2017 Act has come.
My lord.
He is also updated his qualification.
My lord.
Give him a fresh consideration.
My lord.
He'll submit a representation before the director.
Same thing will again come because they are.
Ask Mr. M. Khan Lanak, Counsel for the Petitioner, list this matters again after 3 weeks on a date to be fixed by the registry. Let it be here for some time. You be happy.
Lordship, your lordship will dispose, sir.
No, no.
Because why I am saying lordship, during this pendency of this repetition, they have opted twice lordship the instruction.
What
Same
is, what direction can I pass without having your case considered under by the DLC and the SLC? 3 weeks afterwards, come back. If I'm here, I'll pass that order.
Your lordship, today lordship will dispose. Sir.
Go budget.
God bless.
You finish up the list, then call.
Item 32,
Madam, why are you here? Why are you here? You are not keeping well.
No, my lord, I have the personal duty, other thing, my lord, I have to go. I'm
You
going
please
outside.
go. You please go.
I'm going somewhere, my lord.
You please
That's it.
leave. There is no issue. I only will ask them to get some instructions in the back. So that next date, at least we can dispose of the matter. For that only I kept it.
I'll have that.
You need not be here.
I'll have that.
Happy the lordship. So in this case, we have filed our agenda today, lordship. I created the matter may fixed on 27th of
No, no,
March.
today itself.
Simply the petitioner is engaged senior counsel SK Singh, lordship.
Hmm?
The petitioner is engaged senior counsel SK Singh, lordship. He will be available on 27th of March. Lordship. He will argue the case.
We are available here today. We have the matter before us. This is not done, counsel. Show me your rejoinder.
I'm praying for the earliest date, lordship, 27th of March.
The Islamic Council for the petitioner submits that rejoinder on behalf of the petitioner. Filed today, has been filed today. The registry to tag the same along with the records of the case and list the matter again on 27. 3/2024 as a part of item.
Much better.
33,
32.
My lord, in this case, instruction is evident, my lord.
The provincialization method, my lord. In earlier round of litigations, my lord, during the pendency of the said writ petition, my lord, hearing was conducted, my lord. And that writ petition was disposed of, my lord. And thereafter, as per my instructions, my lord, hearing has been conducted and filed before the government elementary educations, my lord. And thereafter, no development has happened, my lord.
Show me the earlier order,
Earlier order as a
page 62.
page number, my lord, 61, my lord.
Heard the learning council for the petition, also heard Ms. Ms. Shetty, learning standing council, elementary education department. They received that this court wide order is 3/1/2022 passed in WPC number 4049/2021 had required the director, elementary education Assam, to bring to take to its logical end the process of consideration of the grievance of the petition and pass appropriate speaking order there. So it is submitted at the bar that till date, such speaking order as directed to be passed by this court by the order dated 3/1/2022 has not been passed. On the next date fixed, Ms. S. Chutia shall produce before this court the speaking order, speaking order in terms of the directions passed by this court by order dated 3/1/2022. List this matter again on 1/4/2024.
41 supplementary list.
When you have the similar orders with you,
Yes, yes.
give me. Yes,
He
yes.
knows, he knows.
The earlier orders also I was there.
So he is res advocate. These matters have not been disposed of.
These
Yes,
matters have
yes.
not been discussed.
In interview,
Possibly, I don't.
My section disposition in WPC 7613/22. Have you filed your affidavit in those matters?
Yes, no.
Still pending. Yes, what to do, Mr. Kaushik?
So this order of full fund 2021 method. It was basically to ensure that the school maintains that enrollment level.
There are other ways to do that.
Yes, that's true. Madam.
We'll interfere
Otherwise,
with-
but see, in terms of Roman 3 Roman 5 minute,
Hmm.
it has to be on the date of coming into the force of the year.
That is what, this appears to be beyond the
Beyond
powers.
its power.
of-
So that line, subject to the condition of their performance and number of students,
Ma'am.
confirm, we will interfere with that.
Ma'am.
And we will also say that they are entitled to their salaries from that.
Ma'am.
And in the event, we'll also provide for that in the event the authorities find that the teachers in the school are not performing their duties in the manner required, they are at liberty to take appropriate action
In
as may
accordance.
be provided for under the rules
Ma'am.
of 1964.
Ma'am.
That will do.
Action,
Action, yes, you will not teach and you will get,
no, my child, it was happened in the year 2022 only.
we
That is-
will,
the-
madam, we will say that last line is bad. We'll set aside that last line, first paragraph. And thereafter say if you don't work, they will proceed against you.
Second, amalgamate the school also.
Fine,
Government, if
still you don't work, they will proceed against you for dismissal.
No, my lord, they are working, my lord,
That-
because at the time of.
That they are
penalty-
working, that should be reflected in the students' results.
No, penalty.
We can't close our eyes.
No, my lord.
to
that
the
is- that
students'
is only
future.
for the period of 1 year, because at that time it was pandemic, my lord. COVID period was there. And. I
Now
think
it
students-
is how many? What is the percentage now?
at present,
100%, first division all.
I have no idea, my lord, regarding that present situation.
Then you just
Plus if dispose.
get
of
your
them,
salaries,
Yes.
but we will provide that anything is amiss, they will proceed against it in terms of the 1964 rules.
Well.
We will put it in his mouth.
Well.
The heard Mr. KVD, counsel for the petitioners, and Mr. B. Kaushik, standing counsel, elementary education department for the secondary education department for the response. Shown of details, the basic grievance raised, the grievance raised in the present proceedings by the petitioners is with regard to
They have received, my lord, 1 month's salary.
non-release of our salaries with effect from September 2021. Although their services were regularized by order dated 4/1/20, were provincialized by order dated 4/1/2021 with effect from 1/8/2021. Also, shown of details, the projection made, shown of details, the facts are that the services of the petitioners, who were serving teachers in Molua, in
Mondua.
Molua,
Yes.
Molwa High School.
Molua High School, Molua High School, Gulaga, a venture education institution, were taken up for consideration
Yes, sir.
for provincialization of their services under the provisions of the Act of 2017, bracketed as amended. Also, on conclusion of the process involved, by order dated 4/1/2021, the services of the petitioners herein were so provincialized. Also. However, they were paid the salaries for the month of August, and thereafter, the salaries came to be stopped. So, on inquiry, the petitioners were given to understand that as the result of the school in the HSLC examinations were not up to the mark, the petitioners' salaries were stopped. And to this extent, a stipulation was made in the order dated 4/1/2021 that the provincialization is subject to the condition that their performance and the number of students in the HSLC examination 2021 conform to the eligible standards. Also, the respondents have also preferred an affidavit in the matter. I've also filed an affidavit in the matter through the Director of Secondary Education Assam. And therein, it is the stand of the respondents that the academic performance of the school being not up to the mark, the salaries of the petitioners were not released. Also, stop that. The provisions of Rule 316,
Yes, my lord.
3-1 Roman 5, my lord.
That's
no, 5 is 25, that you have it.
Yes, and Roman and Roman
6, 7,
6.
6.
The provisions of the provisions of section 3(1) bracketed Roman 6 of the Act of 2017,
3 years prior.
which is relevant to the issue arising in the present proceeding, is expected. 6 to 3 to what we
Academic year to.
So, a perusal of the order of the provisions of section 316 reveals that the venture education institution to be eligible for provincialization must have a must have a consistent good academic performance, which would mean that at least 30% of the candidates appearing in the final examination as a whole must have passed in the last 3 consecutive examinations held during the previous 3 consecutive years prior to the date of coming into force of this Act. The Act had come into force on 10/9. 10/9, had come into force on so and so 19. 19, I think it came into force.
Lord, I think page 101, my lord.
01 session.
Notification.
No, there has to be a note. There was a notification.
Yes. 11th April 2017, my lord. Page 99.
5/5/2017. That came into force with effect from 5/5/2017. And accordingly, the
No. 5.
years as contemplated under the provisions of section 316 would be the years.
It was, no.
Huh?
Published in the Assam Gazette.
You got it.
Hello?
It came subsequently. Came on
18, okay.
Lordship, it's page 99 down below your lordship, it's in the footnote. Number.
no, mere publication will not do
In the Assam Gazette.
because here 1/3 there was a notification required.
No.
Pointing into it. It came into force on 19/5/2018 or 2019. Just have that date.
My lord, I'll
Dash with it. The 3 years as contemplated under the exams for the 3 years as contemplated under the provisions of 316 would be the years. The respondent authorities while examining, while verifying, while scrutinizing the cases of the petitioner school, of the serving teachers of the petitioner school, had proceeded to issue the order dated 4/1/2021. On being satisfied, on arriving at a conclusion that the petitioner school had fulfilled the eligibility conditions as mandated under section 315 and 316 of the said Act of 2017. Full stop. having noticed the provisions of the Act, more particularly section 316 of the Act, the condition as specified in the order dated 4/1/2021 is to be examined. Also, the respondent authorities while proceeding to provincialize the services of the petitioners, while they said order dated 4/1/2021, incorporated therein the following stipulation. DB, page 14. Huh? A to A. Also, the said stipulation would mean that the petitioners to be eligible to enjoy the benefits of provincialization. No, the said stipulation would mean that the petitioners would be eligible to enjoy the conditions, the benefits of provincialization of their services, subject to the performance of the students in the HSLC examination of 2021. So, as noticed here in above, the provisions of section 316 do not mandate any such condition. So, in that view of the matter, the said stipulation was so incorporated by the respondent authorities in the order dated 4/1/2021 admittedly without any jurisdiction. The said stipulation being in clear violation of the provisions of the Act of 2017, the same stands the same cannot be sustained. Further, the petitioners, although was provincialized with effect, provincial services of the petitioners, although was provincialized by order dated 4/1/2021, the effect of such provincialization was given from 1/8/2021, which is not the contemplation which is not the stipulation as made in the provisions of section 4 of the said Act of 2017. Also, section 4 of the said Act mandates that the services of all teachers and or teachers of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state with effect from such date. Also, the provincialization order in respect of the petitioners having been issued on 4/1/2021, their services have to be deemed to have been provincialized with effect from, at least with effect from 4/1/2021. Accordingly, the respondent authorities could not have provincialized the services of the petitioner while the order dated 4/1/2021 from a future date, that is 1/8/2021. And such prescription as made in the order dated 4/1/2021 has also been made in clear violation of the stipulations of the provisions of the Act of 2017. Also, in view of the above conclusions, the stipulation with regard to the effect, the date of coming into effect of the provincialization of the services of the petitioner, that is 1/8/2021, and the conditions that their such provincialization is dependent upon the performance and number of students in the HSLC examination 2021 stands set aside and quashed. Also, the petitioners would be deemed to have been provincialized in their services with effect from 4/1/2021, So accordingly, the petitioners would now be entitled to receive their pay and allowances in the scale so authorized receive their
Salaries.
receive their pay against the post of tutor with effect from 4/1/2021. Full stop. The Director of Secondary Education Assam shall release to the petitioners their pay with effect from 4/1/2021 as tutors. Full stop. Full stop. The areas of pay of the petition due since 4/1/2021 shall be released to the petitioners by the director within a period of 3 months from the date of receipt of a certified copy of this order. So the director shall, with effect from the month of April 2024, release to the petitioners their current salaries, and the areas would be so released as indicated herein. Also, before parting with the records of the case, a submission as advanced by Mr. B. Kaushik, the Understanding Council, Elementary Education Department, is to be taken note of. Mr. Kaushik has submitted that the stipulations as made by the respondents in the order dated 4/1/2021 was so made to ensure that the students studying in the school receive the best teaching, receive the best coaching from the teachers, and the teachers took all requisite steps to see that the students in the school perform well in the final examination, that is the HSLC examination. Full stop. And full stop. The said objective which was sought to be achieved is a noble one, and this thing cannot be said to be not in tune with the objective for provincializing the services of the teachers. So, however, the conditions as stipulated being in violation of the Act of 2017, this court had interfered with the same. However, the interference with the said stipulation would not bar the respondent authorities from taking appropriate departmental action against the teachers
My lord,
of the school in the event it is found that they are not performing their duties in the manner required. However, any such action taken should strictly conform with the provisions of the Assam Services Discipline and Appeal Rules 1964. With the above observations and directions, the writ petition stands disposed of.
their school's name is already been sent to for amalgamation, my lord. So it will be effective if your lawsuit passes.
From 4/1. You will get the money from 4/1.
No, my lord, I am not that. My lord, the name of the school, Molua High School, their name has been sent for amalgamation, my lord. The list was published.
That is not true.
If your lawsuit passes like that order, it may be effect, my lord.
No.
Now, what effect?
Means maybe delete the name of the school, my lord.
From the amalgamation list.
Yes, my lord. Then they will suffer, my lord.
Another new case.
No, one thing, my lord, if I can say, my lord. My lord, their prayer in the repetition and the challenge in the repetition, my lord, can you see page 8, my lord? What they are claiming for, my lord, the salary since August 2021.
September 20.
September 20. They are basically.
I mean, they will get a
Now,
one
to
month
give
salary.
that relief,
Hello.
Mr. Kaushik, if I can't pass an order,
Well.
to release their salaries without reason. And to reasoning is this interference.
Make interference, my lord, to that aspect, my lord, that the Roman 3:6 makes it very clear, my lord.
You cannot.
We need to see the consecutive 3 years. That imposition is wrong. But the effect of provincialization was given from 1
No,
2021.
effect of provincialization under section 4/1
Madam.
is on the date of notification.
True.
So the date of notification is 4/1.
That is not the challenge in the repetition.
Need not be. Need not be.
Salaries. I
We
no
have-
more salaries.
As a equity court, we did it.
My lord.
If you want, you can go up.
My lord.
See what he is saying. He's questioning
Yes, my
the relief granted to you. See. And you have, what happened? You become very silent these days.
Obligations.
Obliged, sir.
Oh, you Mr. Kaushik, just give me that date.
My lord, in fact, it is there. my
No,
lord.
no, it's not there, it's not
No,
there.
no, no,
You
my
ask
lord,
Mr.
my lord is correct, my lord.
Ah.
It is except 4 and 8,
Ah.
section 4 and 8,
I want 4 also, because without 4, they
Yes.
could not have been provincialized.
4 I will get it, my lord.
You just get it.
And otherwise, this act came on 5/5/2017.
5/5/2017, there is something called 19, so something.
5/5/2017, except 4 and 8. 4 and 8. I'll-
Yesterday or day before, yesterday, Mr. Mozumdar or somebody placed that before. Just ask
I-
it and give it to him.
I'll,
It's 19 million, 19, 18, 7. Already 18, হয়, 18, and May হলে তো পরীক্ষা result হয়ে যাবে। পরীক্ষাটা হয়ে যাবে। 17, 18, 15.
Timing for
Disposal, no? The disposal, yeah. Hmm? Yes, who is appearing for the government? Ms. Burman, okay. Mr. Goswami. You had removed this now. Hmm? This court literally interfered with that and
Yes.
suspended, and the period from 17/6/2001
Lordship.
to 6/9/2001, suspension that was maintained.
Yes, Lordship.
Now, from 6/9/2001 till his reinstatement,
12. 2012.
2012,
Yes, Lordship.
why this period? Because he is not at fault.
Was it, that was. That was, I read the affidavit of.
No, you come to page 17.
Yes, 17 words.
Is reinstated, removed on so and so, reinstated on so and so.
Yes, Lordship.
In the light of the above major penalty, so and so. Therefore, at long time which has elapsed in the meantime, as well as so and so shall be modified by treating the period of suspension from so and so to so and so as punishment. The petitioner is reinstated in service, subject to furnishing fitness certificate, maintaining continuity of service all through, out.
Lordship.
In the light of the order, he will not get anything for the period of suspension. But once you say maintaining continuity all through, he's entitled to salary.
That is not, so far the spirit of the, spirit of this high court, the high court order, the spirit of the high court.
High court
is
order
not-
does not have a spirit.
Yes, Lordship.
It has a body,
Yes.
and that body says suspension. period.
Specific.
And you understood it like that.
Yes, Lordship.
Why will you not take?
That's.
Have your instructions.
Lordship, so far in the affidavit, Lordship, it is stated, Lordship, that, but it is not confirmed.
Nothing is there.
Paragraph 10, Lordship, that with regards to the statement made in.
See, once he is removed, he cannot be unauthorizedly absent.
Lordship.
Hmm?
Lordship.
So you will have to regularize that period. Come with a proposal.
Lordship.
And the removal having been interfered with the substituted penalty,
Yes.
and you have not appealed. So that has become final. So after that, he is to deem to be in service,
Yes.
right?
Right.
And the High Court did not provide for that. Your order itself provides for that, page 17,
Yes.
right? You have only said he is not entitled to any
Yes, sir.
more benefit other than the subsistence allowance receipt. Second paragraph, page 17,
That's it.
last line.
I got it. Yes. It is stated that in the light of the above judgment and order.
No, you come to the last line.
Last line, yes.
The petitioner is reinstated in service subject to furnishing of fitness certificate, maintaining continuity of service all through. Now you see, in the light of the order of the Honorable High Court, he will not get anything for the period of suspension, only period of suspension. So this last line, he gets everything.
Yes.
So you examine this. I just wanted, because Madam wanted, Ms. Swikia wanted an adjournment, but I wanted to have this clarification from you.
But Lordship, here in this writ petition, Lordship, the impugn order dated 30/06/2012 is not challenged.
Need not be, that is in her favor. Page 17 is in her favor.
Lordship.
Why will she challenge it? Heard Ms. N. Sekel on the council for the petition, MS N. Sekel, and also heard Mr. J.K. Goswami. Your additional senior comment. Mr. Goswami, your additional senior
Yeah,
comment.
Lordship.
Additional senior comment advocate appearing for the respondent. Mr. Goswami shall on the next day fix, make his submissions with regard to the issue as to why the petitioner on his reinstatement in service in terms of the directions passed by this court, modifying the penalty imposed upon the petitioner, be not entitled to the salaries from with effect from 6/9/2001 to 2/5/2012. List this matter again when? When?
Lordship, after vacation, Lordship.
Anytime, you give me a date, we will be
Yes.
comfortable.
It is, Lordship, it may be on 19th April.
19th of April.
April.
Huh. On 19th. Anything else.
Lordship.
You just examine.
Lordship.
Now find something.
I will
that-
listen. I will.
Yes, madam.
Item 6, or item 5, sorry, 5.
May I please your lordship, my lord, I have got the instruction, my lord. In the last part of 2014, my lord, a post of junior assistant was located there. The petitioner was offered the promotion in Lakhimpur, my lord, in the post of junior assistant, but he refused. And thereafter, he did not turn back till date, my lord. In fact, my lord, to my information, he is not pursuing the case with his advocate also. Because in the year 2014 itself, he was offered the promotion and he refused, my lord.
Lordship,
To the post of junior administrative officer at Lakhimpur, my lord.
Yes, madam.
Lordship, I may be allowed 3 weeks time so that I can in the meantime get the information regarding.
In fact, my lord, I
Any
talked
date may
to,
be given, Lordship, at least minimum 2 weeks may be given.
today, my lord, I talked to her senior, Mr. S.C. Vishwas also. He is also saying me that he has written so many letters to the petitioner, but he is not responding. Because, my lord,
And would you have
2014,
the
he was
phone
offered the
number also?
promotion.
Hmm?
In the year, last part of the year 2014, he was offered the promotion at.
He did not join.
No, my lord. He refused to join and thereafter he did not turn back to the office of the joint director or director for his promotion till date, my lord.
So it is the norm in your office that one has to approach them for the promotion.
No, my lord.
Then?
He was offered promotion, my lord. He refused. my
1 year, 1 year, why not in 2015 he was considered?
2014, my lord. In the year 2014 itself, he was considered. Last part of the 2014, my lord. He was offered promotion, my lord.
Private respondents are also not.
Yes, my lord, they are not.
Yes, madam.
Lordship, kindly 3 weeks time may be given so that we can contact him one last time.
That is, you don't contact your client. That is none of the business of the court.
We have
We are only
contacted
concerned
earlier
with the issue
also,
before us.
didn't get any response, so
Maximum I can accommodate you till 2nd,
2nd of April,
not a day more than.
5th,
2014, 13, 14 matters we are not
Yes, madam.
inclined.
can it be on 5th of April?
Okay. On the prayer of Miss Yunan, Mr. Bora, Lanark Council for the petition, for the respondents. Standing Council Health and Family Welfare.
Yes.
Appearing for the respondents number 1, 2, 3, 4, 3 and 4. On the instruction submits that the petitioner was offered a promotion. Was offered promotion to the post of upper division assistant
No.
bracket
Uh,
to a post of
LDA,
LDA, a lower division assistant. Now junior
Junior
assistant,
Administrative Officer, my lord.
now junior administrative officer bracket over in the year 2014 itself. However, he refused
In Lakhimpur, my lord, in
Huh?
Lakhimpur.
in Lakhimpur, in the office of the joint director has
Under the Joint Director of
in
Lakhimpur.
offered promotion to the petitioner so and so against a post figuring in the establishment of the joint director of health services.
Lakhimpur.
Lakhimpur. However, the petitioner refused to accept a said promotion. Also. Sapta, Ms. U. Nanda, Lanark Council for the petitioner submits that she has lost contact with the petitioner and accordingly prays that the matter be taken up on 5/4/2024, enabling her to receive the to place before the court the present status of the services rendered by the petitioner hearing. Also, prayer accepted lists this matter again on 5/4/2024. It is mandated, it is provided that no further action in the matter would be granted.
Obliged, my lord.
Much obliged.
6.
Lordship, I beg to apologize, but we are unable to contact our client.
Nothing is here. What is it?
The Lordship may close the matter with liberty.
You want to withdraw it with liberty? Heard, Mr. You are
A. Borwa.
CA.
A. Borwa.
A. Borwa, you are A. Borwa. A. Borwa. Lanark Council for the petition. Also heard Ms. D. Das Burman. Lanark Council appearing for, you are for the Social Welfare Department also, madam. For the respond number 1, 2, 3, and 4. None has appeared, none has entered appearance for respond number 5. The grievance, we'll do it because the grievance raised in the present proceedings is with regard to the non-consideration of the case of the petitioner for appointment public promotion as an Anganwadi worker in number 186 Anganwadi Center under Bozali BAZALI ICDS project. So the petitioner herein was engaged as an Anganwadi helper in the said center on 27/9/2007. Also, the Anganwadi worker engaged in the said center on resigning from the post, the petitioner was allowed to look after the works of the Anganwadi worker in addition to the her works as an Anganwadi helper. Also, the petitioner accordingly was expecting that the respondent authorities would promote her to the post of Anganwadi helper.
Worker.
Anganwadi worker, considering the experience garnered by her. However, to the surprise of the petitioner, it was stated that the respondents issued an advertisement dated 12/11/2012 for filling up, amongst others, the post of Anganwadi worker as figuring in the said Anganwadi center. Also, the petitioner also filed her application in pursuance to such appointment. However, the petitioner was, however, it was the respondent number 5 who came to be selected for such appointment in pursuance to a due process of selection. First off, being aggrieved, the petitioner had instituted the present proceedings. The respondents, by way of filing an affidavit in the matter, have contended that the petitioner at the relevant point of time was not eligible for promotion to the post of Anganwadi worker, inasmuch as she had not completed the requisite residency of 10 years of service as an Anganwadi helper. Inasmuch as the petitioner had joined her services as an Anganwadi helper only in the year 2007. So with regard to the selection held in pursuance to the advertisement dated 12/11/2012, it was contended that the same was so conducted strictly in accordance with the procedure mandated, and the respondent number 5 having been found to be more suitable on merits, the respondent number 5 came to be appointed as the Anganwadi worker of the said center. Also, in view of the said position, the grievance raised by the petitioner in the present proceedings does not merit acceptance. However, Mr. A. Borua, the counsel for the petition, has fervently requested, prayed before this court to permit him to withdraw the present writ petition with a liberty. Full stop. Accordingly, in view of the writ petition stands dismissed on withdrawal, with liberty to the petitioner to institute any further proceedings on a fresh cause of action arising in the matter.
Obliged.
15,
Dispose of, with the above observation. No, to dismiss. Ima?
Lordship, Gandhi just a day's time, I've contacted him,
Hmm?
I'm contacted him, he's in office, so he needs a day's time to get, go home and find out. The order with regard to relaxation of his age, madam.
Okay. List this matter again on 27.
27, I'll be out of state, 27, 28.
Tomorrow?
Tomorrow.
Tomorrow. Kal. यहाँ पे रख दीजिए फाइल.
Yes, sir.
Just send us.
okay.
19,
Otherwise, Mr. Dotto, it will be difficult.
I understand.
He has a point there.
Well, that point he has,
He has.
Other, of course, it doesn't work, madam. That,
Well, forget it. Others we are not, his
Only that-
qualification that we are not worried.
yes, madam, age
But
relaxation.
this thing. is
Yes,
there.
madam, I understand that, madam. But that was not listed after I filed.
Yes, Mr. Gogoi,
Lordship.
your
Lordship,
secretary comes here and
Lordship,
says
kindly come.
something.
On the basis of that communication, Lordship, director has, Lordship, that was done, Lordship. Secretary has directed the director to examine, Lordship. After examination, my lord may kindly peruse page 57, Lordship.
What are these letters?
Lordship, page 50. Here, Lordship, that when matter was came up before his honorable court, when director was, commissioner was personally appeared, that day my brother has communicated the court proceeding, what was court sought by, Lordship. On the basis of that, along with my brother's letter, Lordship, commissioner and secretary office sent it to the director, Lordship. After director examining, my lord may kindly peruse page 57. In our
Of the
affidavit,
writ petition.
or the affidavit filed by Lordship, secretary, Lordship.
Hmm.
Secretary has filed the affidavit, Lordship, where the report of the director is annexed here, Lordship. Page 58 is found that, Lordship, that two persons has already retired, Lordship.
We are not worried.
Lordship,
We are not worried.
Lordship,
They have got it
Lordship,
by way of what do you call that, misrepresentation.
Lordship.
So Rafiq Mashik
No,
automatically will not come.
no, Lordship, it is the fault of the officials also, Lordship.
Whoever is recovering
Lordship.
from them.
They have done,
But the persons who are there,
Lordship.
how can you apply the principle of Rafiq Mashik?
Lordship.
So do one thing,
Lordship.
pay her also.
Hmm.
We will say, that
part
pay her,
of- that-
you will not, Rafiq Mashik, you will not recover.
That
I'm
part,
passing that order.
that part, Lordship, I will argue, Lordship. That part I will argue. Lordship. Otherwise,
But we
Lordship,
want this order to be others to be done, because that is the undertaking.
Lordship,
That is the undertaking.
Lordship.
You
Now,
argue whatever you want, you are free, no problem.
Lordship.
You are most
under-
welcome. You
under-
come to page 45.
Lordship. Page 45, Lordship.
Come to the second last paragraph.
Lordship, Lordship.
Whereas so and so find out if such benefit was against so and so given up in a letter, the illegal benefit cannot be cited as a precedent.
Lordship,
Till here, I have no objection.
Lordship.
Correct.
Lordship.
Now see. As issued show cause notice to so and so who has been allowed regulation benefit
Lordship,
from the date of joining, although she acquired MPhil in 2010.
Lordship.
And you, what do? This order is passed on 8/2. On 27/3, the government releases to her the money. So how can Rafiq Mashik come here?
That part, Lordship, I have nothing to say because.
No, I wanted the director, the what do you call that? Your commissioner, secretary, to exactly do that.
Lordship,
And now see what they are saying,
Lordship,
that we can't do it because ask your director to be here.
Lordship.
Seen the,
Lordship,
the,
Lordship, I pay, Lordship, may give some time, Lordship.
how much more? time?
Lordship, I will come back, Lordship, after 10 days, Lordship, may fix it, Lordship. After 10 days, we will come up with it. After 10 days, Lordship, may fix it.
The secretary to the Government of Assam Department of School Education has filed an affidavit on 15/3/2024 in pursuance to the undertaking as given by him before this court on his personal appearance on 25/1/2024. So on perusal of the said affidavit, it is seen that the undertaking as given was not complied with. Further,
Yes.
said affidavit brings on record a communication from the Director, Secondary Education Assam, Higher Education Assam, dated 16/2/2022, wherein the director has opined that the recovery of the payments illegally held to be paid to the persons mentioned therein cannot be recovered, referring to the case, referring to the decision of the Supreme Court in the case of State of Punjab and others versus Rafiq Mashik bracketed whitewasher. This in view of there being a clear undertaking in the order dated 8/2/2017 issued by the Direct Commissioner and Secretary to the Government of Assam Higher Education Department, that proceedings have been initiated against one Aparna Tamuli, lecturer so-and-so, lecturer ADP College, Nagaon, who was allowed the regularization benefits from the date of her joining, although she had acquired MPhil qualification in 2010. Full stop. The said stipulation as made in the order dated 8/2/2017 clearly reflects that the authorities were alive to the fact that the payments as made to the said person was so made without any authority. However, the payments so made have not been recovered. Rather, after passing of the order dated 8/2/2017, on 27/3/2017, the arrears that would be available in the matter was duly released to said person, ignoring the ignoring the stipulations as contained in the order dated 8/2/2017. Full stop. Mr. K. Gogoi, Learned Counsel for the petitioner summons that he be given 10 days time to take remedial action in the matter. Full stop. As a last chance, Mr. Gogoi is granted 10 days time to take remedial action in the matter and for withdrawal of the letter dated 16/2/2024. Full stop. In the event the remedial action, which would be nothing less than recovery of the amounts illegally stated to have been paid to the persons mentioned in the communication dated 16/2/2024, is not recovered or steps taken for such recovery, this court would be left with no other alternative but to allow similar benefit to the petitioner and or proceed against the officers who had facilitated such release of illegal benefits to the persons mentioned in the communication dated 16.
Lordship.
There has to be a limit.
Lordship,
We are not saying you give him, but
Lordship, they have crossed the limit.
They
They
have-
also, I have said that they have
But
crossed the
Lordship-
limit, Lordship.
Lordship, I was appointed in a pre-revised.
They have-
sit-down.
Lordship, they have
Mr.
crossed the
Mr.
limit,
Mr.
then petitioner has no right, Lordship. On what right?
you don't have it.
What right he have, Lordship?
52%.
You have put your point across.
Petitioner have
Why
no
do
right,
you-
Lordship, and officials
Mr.
have
Gogoi,
crossed the limit, Lordship.
Mr. Gogoi,
I have an order of the court.
Mr. Gogoi,
Lordship,
Mr. Das,
Lordship,
Mr. Gogoi,
Lordship,
you have put the point across.
Lordship.
No? Why do you raise your pressure? Huh?
Lordship.
By raising your pressure, you are lowering yourself before me.
Oblige,
And I don't want that to.
oblige, Lordship.
Lordship, this revised UC norms.
You have done your part.
Oblige.
You also know what is happening, I also.
Lordship.
But this message should go.
Lordship.
Don't raise your pressure.
Lordship.
Because by raising your pressure, this is not the first time I'm telling you.
Lordship.
Outside also I've told you.
Lordship.
You lower yourself.
Lordship.
And I don't want that to happen.
Lordship.
And
Mr.
Lordship-
Das, wait for something.
Yes, Lordship, the revised UC scale was with effect from 1/1/86.
We
I
will
was
see,
appointed
we
in
will see.
85.
Mr. Das, we
He
will
has to
see.
write, Lordship.
You have brought something on record. They have said there it's illegal. They have paid it to others. Let's see what they do.
Lordship.
Then we will see.
Lordship,
And if they do nothing,
Lord-
this would be the last court for negative equality. Take that from me.
Lordship will fix the date, Lordship.
And
after 10 days.
whatever amount if I have to direct to pay to you,
Lord.
that will be recovered from the officers.
Yes, Lordship.
I'll ensure that.
Lordship.
Whatever they do on appeal, they do.
Otherwise, Lordship, claim for UGC scale of.
It is not there.
He should-
It's not there.
Lordship.
But why did you
Lordship,
also know
Lordship.
why you are taking this stance today?
Lordship.
I would not have even minded
Lordship.
if that stipulation was not there in her order rejecting her claim.
Lordship, that is the issue. That's why I'm saying that they have crossed the limit, Lordship.
So after 10 days, Lordship will fix it on. 1st of
10
April.
days,
First of
when
April.
Mr. Gogoi?
1st of April.
Lordship, immediately after view vacation or
No,
Lordship?
No, we will have it on 8th,
8, Lordship.
8/4,
8, Lordship. 8.
right?
Lordship. Oblige, Lordship.
30 and 31.
Yes. Heard Mr. M. Khan, Learned Council for Deputation. And Mr. P. Bora, P.K. Bora, Learned Council for the Learned Standing Council, Elementary Education Department, appearing for the state respondents. So, list this matter again on 22/4/2024. So, on that day, we will see. You finalize, streamline your argument.
I don't know, already I have finalized your lawsuit with this one.
That was the proposal of this group. You did not like it.
But I
You accepted.
accepting.
That's why we said we will pass it on 22nd.
Right.
On that.
God bless.